Greetings, ladies and gentlemen. Welcome to Burn the Corporate Fiction. Today, we are going to be talking about the purveyors of the satanic New World Order digital beast system, the ones who are indispensable for implementing it, even creating the framework by which it's being implemented. And that would, of course, be the infernal Inns of Court and their bar associations, their minions, right? Really, all bar associations are but one bar association under the International Bar Association, which is, of course, controlled by the Inns of Court out of London. So they're in the old Templar Church, right? Now, the Inns of Court and the bar associations are, so let's put it this way: the Inns of Court are an unincorporated secret society that I believe, and I could circumstantially prove, serve the devil himself. The bar associations are communist guilds of lawyers, well, not even lawyers, attorneys, and that's an important distinction that we're going to make here shortly, actually, because to attorn or an attornment is to transfer homage and service from one feudal lord to another. So we'll take a look at that right out of Webster's 1828 dictionary. They're not actually lawyers at all. And they are, even just by purporting to practice law, are acting outside of their scope, right? Their duties. So we're going to get into that. But before I do, I want to start this off with showing you the ultimate end of these neo-feudal communist technocrats and their devilish minions that we call attorneys. You guys will find this very interesting, but this is, in fact, where they're going with it. Here you go.
Good morning, citizens. Your overnight account balances have been updated. Time to start a productive day. Final notice, your account balance is below 500. You need 50 credits by the end of the day to avoid automatic eviction. If you have missed work due to illness, you must provide a doctor's note to reclaim your credits.
Any extra credits? Please.
Tensions are high today, with more people planning to join the Citizens Against Digital Control protest. Remember, the government knows who you are at all times. Resisting is not worth the consequences. All of their newest social credit systems are designed to keep you and your families safe and efficient.
Authorities seized a record balance of an individual's credits, citing excessive hoarding.
Traffic violation detected. 7 miles per hour over the limit. 75 credits have been automatically deducted.
You have to be fucking kidding me.
Yep, you got the flu. Your blood work shows a significant iron deficiency. I recommend incorporating more red meat into your diet.
Dr. Jones, your taxes were not filed and have been automatically deducted with late fees. Your medical license has been revoked.
Oh, hell nah. I filed an extension.
Purchase denied. Monthly red meat allowance exceeded. Try mealworms instead.
Can you guys please let me through?
Attention. Unauthorized political gathering detected. Participants' access to financial services has been suspended. Due to the speeding infraction, your car will be immobilized for 3 days.
Fuck you! Take your surveillance policies and rot in hell!
You've earned 50 bonus credits for reporting your neighbor's hateful misconduct. This content exceeds your current social credit tier. May we suggest citizen responsibility? Sarah, open the door. You have been identified by the authorities. Don't resist. Don't resist. Don't resist.
Yeah, Palantir ad, allegedly, but whoever created that, that is highly accurate. That is not science fiction. That is exactly where they are going with this. And if you trace the law back and exactly how they've done it, you'll see that there's no other place they would be going, right? So the funny thing about it, that's where we're heading. Now, how have we gotten to where we are now? That's what we're going to be going through today. And the architects of this entire thing are the Inns of Court, well, and through their bar associations primarily. Those are the frontline soldiers. See, the Inns of Court are the knights, and the bar members are the esquires, the scutifiers, the shield bearers, the ones who carry out the orders and attend to the knights, right? And their hopes one day to be a knight, like, for instance, Chief Justice John Roberts is, I believe it is, a member of the Middle Temple of the United States. So there are, in fact, Inns of Court in every major nation, right? Australia, United States, obviously England is the headquarters, London specifically. So this is where we are heading. How did we get here? Well, believe it or not, in order for them to build this system, they had to create this nation first. There's several reasons why, primarily two. First, they had to reset the board. Okay, they had to give us a fair shot of retaining our freedom. And in order to do that, they had to give us our freedom. And I'm going to show and prove to you that originally, for about 10 years in this country, right, we were absolutely free. And then with the creation of the federal judiciary, through the usurpation of the Constitution over the Articles of Confederation, they began eroding our liberties. See, what happened, let's take a look at this real quick. We have the Articles of Confederation. I want to point something out to you. All right. In the Articles of Confederation, if we do a word search, for the word judicial or judiciary, check this out. It only appears one time. You see this? 1 out of 1, one time. And it's only saying the full faith and credit shall be given in each of these states to the records, acts, judicial proceedings of courts and magistrates of every other state. That's it. There was no federal judiciary. It was one of the main reasons they had to get rid of this. I'll show you another reason, right? That this right here, Article 4, the better to secure and perpetuate mutual friendship and intercourse among the people of different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, meaning obviously not included, but free inhabitants shall be entitled to all the privileges and immunities of free citizens. So citizenship is and always has been optional. You could be a state national. That's 100% a fact. And you had all of your common law property rights, because all titles, all lands in this republic are allodial and feudal tenures are prohibited. Article 1, Section 14 of the Wisconsin State Constitution, combined with Article 4, Section 2, the Equal Footing Clause, where all states enter in to the union on the equal footing with the original 13 states, proves that there is no way Wisconsin could put that into their Constitution if that was not the case everywhere. And of course it is, as later confirmed by a report from the Commissioner of the General Land Office to the Secretary of the Interior in 1870, which I've shown several times. Not going to show this morning. Watch my previous stream if you do not believe me, because I always bring the receipts. So this was huge, right? You could just free inhabitant, have all the same common law property rights as a sovereign as the state citizens. Okay. And one of the biggest reasons outside of that is this, Article 5. For the more convenient management of the general interests of the United States, delegates shall be annually appointed in such a manner as legislature of each state shall direct, to meet in Congress on the first Monday in November and every year, with the power reserved to each state to recall its delegates, or any of them, at any time within the year, and to send others in their stead for the remainder of the year. There's no lifetime senators and congressmen. There's none of that. None of that happening under the Articles of Confederation. You can't have these mummified corpses haunting the halls of the Capitol building, right, for eternity. No, you have 1 year. And you know what? If you didn't do exactly what we wanted in that 1 year, your ass is done. And we're going to send somebody else. So obviously the Bar Association, who were the signatories to the Treaty of Paris, every member or every signatory from our side to that treaty was a bar member. And there were plenty of bar members, of course, amongst the numbers of the founding fathers. And these bar members have foreign allegiances, which is why we had the original 13th Amendment forbidding titles of nobility. For those of you who do not believe me about that, of course, I'll show you. Right here. This is a fact. Okay, so each law book that was printed, throughout the 1800s, so it should still be the same way today, had the state constitution, the federal constitution, the Declaration of Independence in it. Okay, well, Article 13, and this is the revised codes of Virginia from 1819, and in it, the original Article 13 is written, or printed rather. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present, pension, office, or emolument of any kind, whatever, from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them, right? So that's very important, because what is a bar member? Well, we'll go to Webster's 1828 dictionary and we'll look up esquire. They are esquires, all of them. You'll see this after their name every single time. I'll show you. Yeah, you can see it here. I'm typing it out. ESQ. Period. Right? They even made a movie with Denzel Washington, Roman J. Israel, Esquire, right? As if that isn't a whole bunch of subconscious programming that they're trying to do there with Rome and Israel and esquires, right? It's kind of just a way to show you in your face, this is where it's coming from. But anyway, let's look up esquire, right? Shall we? Yes, absolutely. Dun and Bradstreet. So an esquire is a shield bearer or armor bearer, scuttifier, an attendant on a knight. Hence, in modern times, a title of dignity next in degree below a knight. In England, this title has been given to the younger sons of noblemen, to officers of the king's courts and of the household, to counselors at law, justices of the peace, while in commission, sheriffs and other gentlemen. In the United States, the title is given to public officers of all degrees, from governors down to justices and attorneys. Well, according to the original, because this again is 1828, the original 13th Amendment, that is not supposed to be a thing. So let's talk about what happened with the Articles of Confederation, right? This impenetrable, excellent document. Well, first, let's travel back a little further, right, to the Articles of Association, which very few people know about. This is in the years, this is 1774, the years leading up to the war. And essentially, well, we can read that from the, let's see, where is it at here? It says, affected with with the deepest anxiety and most alarming apprehensions at those grievances and distresses with which His Majesty's American subjects are oppressed, and having taken under our most serious deliberation the state of the whole continent, find that the present unhappy situation of our affairs is occasioned by a ruinous system of colony administration. Well, we're in the same position today. They have replaced our de jure government with an administrative corporate system. That's it. Every state adopted a copy of the Administrative Procedures Acts, and all quote unquote judicial branches of each state are no longer public offices. They're private. I'll show you that here shortly as well. In fact, we can pop right over here just so I don't forget to show you. This is Michigan's Freedom of Information Act handbook, right? So it tells you what a public body is, right? It says a public body is a city, village, township, county, or state department, or under the control of a city, village, township, county, or state department. It's required to designate an individual as the public body's FOIA, Freedom of Information Act coordinator, right? So what entities are not public bodies? Several governmental bodies are not public bodies as defined in the Freedom of Information Act. The governor, what? The lieutenant governor, what? The executive office of the governor, so the entire office is no longer a public body, right? And any employee of either executive office is not a public body. Now check this out, it gets even worse. The judicial branch of government is not a public body. When acting in the capacity as a clerk of the circuit court, the office and the employees of the county clerk are not a public body. Wow. Wow. An individual legislator is not a public body. But I thought the public body was a public office, right? So, nope, not anymore. And that's because of the Administrative Procedures Act here in Michigan would be 1969. You'll have to look at your own specific state, wherever you're at, if you're in the United States, and figure out when you guys enacted the Administrative Procedures Act, because absolutely you have one. And it replaced your entire de jure government, your systems, the legislation, the executive office, and the judicial branch with administrative agencies. Why? To administer the bankruptcy, to regulate the property held in trust as collateral for the public debt, since they issued you a social security number after mortgaging your estate because you're a 14th Amendment citizen, and they could do that. Is your public chattel, your award of the federal corporation, and they did what was in your quote unquote best interest by mortgaging your property rights to back the issuance of Federal Reserve debt securities, right? Each of which are mere promissory notes and not actual lawful money, transferring the debt obligations, which are secured by your sweat equity, to the property quote unquote purchased with them. So you never actually buy anything. You trade debt in color of title, junior titles. That's it. You playing a big game of Monopoly under the supervision of daddy government. So let's get back here to these articles of association. So occasioned by a ruinous system of colony administration, check, we're there right now, adopted by the British ministry about the year 1763, evidently calculated for enslaving these colonies, check, and with them the British Empire, in prosecution of which system various acts of parliament have been passed for raising revenue in America, income tax, property tax, right, licensing, registration, administrative fees and fines for violating administrative regulations. Hell yeah, it's all revenue here today. We're in the same position, which is why I say, if ever you needed a just cause for a revolution, we already have it. We just need to get the people to see it. For depriving the American subjects in many instances of the constitutional trial by jury, exposing their lives to danger by directing a new and illegal trial beyond the seas for crimes alleged to have been committed in America. Beyond the seas, admiralty courts. That's where we're at right now. All of these traffic tickets and all this crap, right? It's an administrative hearing, right? But it's only made possible. It's like a sublet of the special maritime territorial jurisdiction outlined in Title 18, Section 7 of the United States Code. That's what's going on, right? That's why the term motor vehicle is defined in Title 18, which is crimes in criminal procedure. What? Why would it be defined in Title 18, crimes in criminal procedure, unless you intend on placing the whole system of revenue generation for traffic offenses under that general jurisdiction, which is special maritime territorial jurisdiction. So we have that going on today as well. Beyond the seas, and in prosecution of the same system, several late, cruel, and oppressive acts have been passed respecting the town of Boston and Massachusetts Bay, and also an act for extending the province of Quebec so as to border the western frontiers of these colonies, establishing an arbitrary government therein, and discouraging the settlement of British subjects in that wide extended country, right? Thus, by influence of civil principles and ancient prejudices, to dispose the inhabitants to act with hostility against the free Protestant colonies, whenever a wicked ministry shall choose so to direct them. So my point in showing you this, and also just as a side note real quick, because they tell you that the Civil War was about slavery, when in fact we were phasing slavery out before we even became a nation. This is Article 2 of the Articles of Association. We will neither import nor purchase any slave imported after the 1st day of December next, after which time we will wholly discontinue the slave trade, and will neither be concerned in it ourselves, nor will we hire our vessels, nor sell our commodities or manufactures to those who are concerned in it. So not only were we like, we're done with slavery, this is 1774, we're done with slavery, and not only are we done with slavery, but we will not do business with anyone who still engages in it. Right? But see, they had to stoke up that narrative, the Hegelian dialectic, to make sure blacks and whites never unite against the real people who are screwing us over. Well, that's what I aim to remedy. is dispel and destroy that illusory, his story, if you will, right? So we are in the exact same position today as we were, as the colonists were when they decided to declare their independence, and worse. And the entire purpose of the creation of this country was to get away from that administrative system. In fact, the entire history of law for the last 1,000 years has been a battle between Roman civil law, which I like to call the devil's law, and common law, which is created by God and recognized by man, which I can prove time and time again, actually. We can pop over here. This is the Heart of Blackstone, the source of the common law. This is written by a law professor or a lecturer at law for Washington University. Okay, just so you guys know, this isn't just some average individual. This is actually a well-trained bar member. And they even admit the source of the common law. The common law is grounded upon the general customs of the realm and includes in it the law of nature, the law of God, and the principles and maxims of the law. It is founded upon reason and is said to be the perfection of reason acquired by long study, observation, and experience, and refined by learned men in all ages. Nowhere in there does it say we created it. It actually specifically says study, observation, and experience, because we did not create common law. We did not create common law. Is that natural law as applied to society. It's the law that's written on the hearts of mankind, combined with the customs and practices of the people that arise from the practice of these, or from the exercise of these laws. At no point in history did we make it a crime or declare it to be a crime to kill somebody. Who did that? God, right? That was through revelation, the 10 Commandments. Okay. At no point throughout history did we make it wrong to steal from somebody. We didn't just arbitrarily write that down. That again was revealed. And not only that, but it's written on your heart in such a way that that if you, from the time you're a child, if you hurt another child, make them cry, you feel bad, as long as you're not a sociopath, and they do exist, psychopaths for sure. So we'll pop over the Heart of Blackstone. Okay, the Heart of Blackstone. This law, actually, where should we start? We should start here. In consequence of which mutual connection of justice and human felicity, which means happiness, has not perplexed the law of nature with a multitude of abstracted rules and precepts, referring merely to the fitness and unfitness of things, as some have vainly surmised, but has graciously reduced the rule of obedience to this one paternal precept, that man should pursue his own happiness. This is the foundation of what we call ethics or natural law, for the several articles into which it has branched in our system amount to no more than demonstrating that this or that action tends to man's real happiness, and therefore very justly concluding that the performance of it is part of the law of nature, meaning it's written on your heart, and what leads to your happiness is doing the right thing. When you do wrong things and you injure other people, you suffer. You bring suffering upon yourself, even if nobody else knows about it except for the person you harmed, right? You still bring suffering upon yourself. So doing what's right is intrinsic to your happiness, right? Which makes the natural law the intrinsic and underlying fabric of all of creation. And that is what they seek to subvert. That is what every conspiracy is about. That's why these people are truly satanic, right? There are not multiple conspiracies. There's just one conspiracy, and it's all aimed at subverting God's law and taking his throne, right? That's what it is. Like NASA, everything, I'm not going to get into the other conspiracy, but every other conspiracy all comes back to this and is leading towards the creation of a one world technocratic communist police state, which we are on the threshold of right now, right? And the reason all of these other conspiracies were enacted, say the heliocentric hoax, the germ theory, everything is meant to distance you from God and have you put a superior faith in man to save you and tell you what to do. Because once you do that, then communism can very easily be implemented. In fact, if you look at China, they only allow CCP approved copies of the Bible to be sold in China so that it doesn't inspire any kind of, rebellion or realizing that you're actually serving Satan by listening to that corporate state. That's how that works. Okay. So it says, on the other hand, this or that action destructive of man's real happiness, and therefore that the law of nature forbids it. Now, this law of nature being coeval with mankind and dictated by God himself. Okay? And for those of you who don't know, this is written by Sir William Blackstone. It's called Blackstone's Commentaries on the Laws of England, 1765 to 1769. There's 4 books. And this particular series of books, these volumes, have been the foundation of the very first Supreme Court rulings, and actually all throughout the 1800s, Supreme Court justices continuously and constantly reference Blackstone as the oracle of law. As the oracle of law. That's a fact. Okay. In fact, one pissed off New York bar attorney, I had it and I just stopped reading it because it was stupid. But this New York bar attorney's like, well, he's irrelevant now and we should stop citing him and listening to him and blah, blah, blah. No, absolutely not. It's because you're a communist. And he tells you that the fount of authority is never man. It's always God. And as we're about to read, anything that man tries to enact, which he never calls law, he calls it a statute, code, rule, regulation, decree, prerogative, right? And if he does call it a law, he has to put a prefatory statement behind it, like statutory law, administrative law, canon law, right? Trust law. But when you see just law, it is referring to the one and only law not written by man. And attorneys hate this. And they hate when somebody like me or you knows this and can prove it, as I'm showing you how to do. By the way, this is page 42 in book 1 of Blackstone's Commentaries. So, this law of nature being coeval with mankind and dictated by God himself is, of course, superior in obligation to any other. It is binding over all the globe, in all countries, and at all times. No human laws are of any validity at all, if contrary to this, the natural law, right? And such of them as are valid derive all their force and all their authority immediately or immediately from this original. What does that mean? That means in order for them to give their statutes any force or effect, they have to be able to trace it back to the natural law. And then you go, okay, well, how come they can, do so many things that are contrary to law? Well, they're not supposed to, and you're supposed to be able to have relief, remedy, the avenue for remedy against that, doing a writ, which I'll show you in a second. And I'm going to show you why we're past that point. Not that it doesn't mean, and I'm not being negative, I'm not saying be hopeless. No, I'm very optimistic about our chances of winning, but we need to teach people the law, right? So what does he mean by immediately or immediately to the original law, the natural law? What that means is they have to be able to either trace your free will consent to be under this system that exists outside of the law, right? Generally called statutory systems or Roman civil law, or what they have enacted has to be directly in accordance with the law. Okay, so that's why they capitalized on the creation of trusts, because trusts are entered into, or supposed to be entered into, by free will and consent. Now, you do not even have to sign a paper that says, I agree to be in this trust. It is presumed that if you are entering into an implied trust, which is what the 14th Amendment citizenship is, as an unincorporated banking association, all engaged in the common commercial enterprise of discharging debts instead of paying them, which is both against the law and against the Constitution, right? But it's a fictional scenario here. And your use of the Federal Reserve notes and the Social Security number have entered you into an implied trust called an unincorporated banking association. There's so much legislation about banking associations and savings associations, right, in the Code of Federal Regulations, United States Code, that they can apply to the 14th Amendment citizens without actually specifically calling them citizens, because you are an unincorporated banking association. But because you freely and willingly do this, or so they claim until you rebut it, right, you are presumed to have consented to this arrangement. And so therefore they can trace it back to the natural, unalienable right and unlimited right to contract. That's what they trace it back to. And that's why they always have to tell you what they're doing. And that's why they always have to show you what they're doing. Just like they are with the new movie that's coming out with Chris Pratt about AI capital governance, right? It's this AI capital court. It's supposed to be this thriller futuristic dystopian thriller where they're like, too many people get away with murder. So they set up a capital court governed by AI, and the person sitting in the court has 30 seconds to prove to the AI that they did not do whatever capital offense they're being accused of, or they're summarily executed. And Chris Pratt, of course, is the hero who's accused of killing his wife. And now he's sitting in the AI court, and they're going through and doing some sort of virtual investigation via proxies through the AI to try to prove that he didn't do it. And see, this is supposed to leave you with the impression that, oh, AI governance will be so much better than human governments. It'll be so just. Well, the problem with that is that the AI governance is going to look at the Supreme Court as if they're God. And the sole purpose of the creation of the Supreme Court was to subvert and usurp our sovereignty. 100%, which they have. See, as I said at the beginning of the stream, they could never set up this digital neo-feudal system if they did not first create this country of truly free common people. We were truly free for about 10 years, and that takes us back to the Articles of Association. Boom. Now, what happened to the Articles of Association? Well, from 1777, enacted in 1779, I believe it was, but it was still the operating governmental document from 1777 onward, through the war and everything. It lasted about 10 years. Then 1787, a bunch of scumbags that people mistakenly view as honorable and noble founders of this country got together and said, okay, now it's time for the next stage of the plan. We cannot allow the common man to have, sovereignty. Basically, it's all revealed in Eliot's Debates, Volume 5, okay, which I had, and I have to get again. It was on my SD card that just got wiped out. But if you don't believe me, just look into this. Eliot's Debates, right? And James Madison is quoted in there as saying, if the interests of the many unite, then the interests of the few will not be taken into consideration. Therefore, they must centralize the government so that when the government is kept in small pockets, towns and communities, right? And the ultimate authority is an elected official who's charged with protecting the law first and foremost and making sure it is not subverted. Then the people have full control because they all have common interests and beliefs and views, and they all know each other. And it's very easy for them to unite together and take that person out of office if they become tyrannical, right? But when you centralize power, as they've done now through the 14th Amendment, there's too many, it's too diverse, right? Like there's so many different cultures, and now with immigration and everything that's been going on there's too many diverse cultures and beliefs and attitudes and viewpoints for them to unite, for us to unite adequately in order to topple the tyrannical government. That's just, and that was the purpose of the Constitution. The second purpose of the Constitution was to create a federal judiciary, which again, if you're just now joining me in the Articles of Confederation, I've typed the word judiciary or judicial or just Judah right there, Judi, into the word find, and it only appears once in the entire article, and it's talking about the judicial proceedings of the states. There was no federal judiciary. So Thomas Jefferson, being the astute individual he was, knew why they were doing this. And so let's read a few quotes from Thomas Jefferson that you can verify yourself. This I just pulled up because it's a great collection of them, but each letter is referenced, and you can find it on founders.archive.gov. So he says, nothing in the Constitution has given the federal judges a right to decide for the executive, no more than the executive to decide for them. The opinion which gives judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch. And see, anytime you get into a debate with AI, and I usually win because I bring up these quotes, especially because no matter how much law and how many citations from treaties and prior cases you bring up, it's always going to go, well, the Supreme Court's never upheld this. The Supreme Court's never upheld that, until you get it to realize that the Supreme Court is a despotic body, right? They're communists, and their sole purpose of creation was to undermine the fundamental freedoms of the citizens of the states and the people of the states. Because remember, you didn't have to be a citizen. You could just be a national, an inhabitant, right? So this, he says, the original error was in establishing a judiciary independent of the nation. Now, remember, what he means by that is that these aren't even elected offices. They're appointed for lifetime terms, okay? Like emperors. He said, so the original error was in establishing a judiciary independent of the nation from the citadel of the law, which from the citadel of the law can turn its guns on those they were meant to defend and control and fashion their proceedings to its own will. It's a letter to John Wales, Epps, right, 1807. He says, you seem to consider judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy, which it has. Our judges are as honest as other men, and not more so. And their power is the more dangerous, as they are in office for life and not responsible as other functionaries are to the elective control. The Constitution has erected no such single tribunal, knowing that to whatever hands confided with corruptions of time and party, its members would become despots. That's a fact, right? So he says, this is my favorite one. The germ of dissolution of our federal government is in the constitution of the federal judiciary. An irresponsible body for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped. Now, as you read in the Articles of Association and in the Articles of Confederation, it was very well known that this, the crimes beyond the seas, the institution of admiralty inland to commit inland piracy, was carried out by the bar associations under the direction of the Inns of Court. They were very well aware of this. And that's why the people were so pissed. Generally, you can look into the history of this. Like, the general public was entirely against the creation of the Constitution. So when they had the ratification or the Constitutional Convention, they had to have armed sentries outside of the convention, making sure nobody was eavesdropping on what was being discussed. Does that sound honest to you? No. Does that sound of the will of the people? No, absolutely not. Right? And then records of what was discussed wasn't released until decades later in Eliot's debates, referencing James Madison's quotes in his personal diary and all that stuff. So, and it was thoroughly sanitized. Not everything is in there, because there were certain things that were discussed that they would never let the public know, and now it's becoming apparent what those things are. And it was ultimately the usurpation of the law by equity. So let's talk about this for a second, right? What is equity? Well, first, before we even get into equity, right, let's talk about how they actually ratified this. They did it by convention and rushed it through the states, and that's why. And they did it while Thomas Jefferson was overseas in France on a diplomatic mission, right? A diplomatic trip. He was in France, and that's when they did it. And when he came back, he was pissed. Patrick Henry refused to even attend the convention. And when he was asked why, he said, because I smell a rat. He said, why would we accuse this form of government, which saw us through a war with the greatest empire in the world, right? Why would we accuse it of incompetence or something to that effect? Which he had a very good point. Well, the truth of the matter is, we only had our freedom because ultimately the plan was to have it taken by corporations. See, here was the issue before this country became a country, before this republic became a republic. Here was the issue. These merchants were creating trusts called corporations, and they were becoming immensely wealthy. But these corporations, which were essentially governments they were mobile governments, like the East India Trading Company, the Virginia Company, the Hudson Bay Company. They're mobile governments with their own militaries, their own, admiralty laws, everything. And they would set up shop and colonize an area and be in charge of administering that colony. And that's what was leading to the tyranny, right? But the problem is that they were still under the kings and queens and still under the Pope. So they needed to fix that. Well, how are they going to fix that? They created an independent nation where the common men and women were truly free. If you don't believe me, we'll just take a look at this. And I show this all the time, but it's always just the best way to shut anybody up who's like, we've never been free. All right. So you search at the revolution, and it only appears twice. You go to the second one, and it tells you right here. At the revolution, the sovereignty devolved on the people. They are truly the sovereigns of this country, but they are sovereigns without subjects, and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. And then it goes on to tell you that it says in Europe, the sovereignty is generally ascribed to the prince. Here it rests with the people. There, the sovereign actually administers. There's that word administer again, that's trust, right? Administers the government. Here, never in a single instance. Our governors are agents of the people and at most stand in the same relation to their sovereign in which regents in Europe stand to their sovereign. So they are beneath us. They are subjects. And it says their princes have personal powers and dignities and preeminences. Our rulers have none but official, nor do they partake in the sovereignty otherwise or in any other capacity than as private citizens. So while they are serving a term of office, they are indentured to us. They have entered a trust indenture, because that's what government is a trust. That's what corporations are. They're trusts, right? They're just a different form of trust. They don't call them trust because they have an entirely different purpose. But the substantive origin of corporations is the concept of trust, right? So this right here proves it. But they had to give us our sovereignty so that their corporations could take it. Now, how could they take it? Presumptions of incompetence and dependency. Okay, we'll take a look at this. What do you mean dependency? So, well, first, in order to start even talking about dependency, let's pop back over to Blackstone real quick and go down to page, what is it, 47, I want to say, maybe? Sounds about right. 47. No, it's man, necessarily a creature. I'm trying to remember. It's like 4759. Let's see here. Man is a creature. This is about dependency. So it's got to be up further. Yeah, it is. I remember where it's at now. It's earlier. It's like towards the top. Okay, this law of nature says, see, the Blackstone's commentaries I had also got wiped out with my SD card, so I have to re-download that. And yeah, this I'm unfamiliar with how to navigate this website that has this, but I think it's up towards the very, very top. Anyways, I'll tell you what it said so I don't have to hunt it down. It says man as a creature is necessarily subject to the will of his creator. You know what? I'll do this. Control find man as a creature. No. Man as a, no. How annoying to not be able to have this on deck. Very frustrating. I've shown it many times. So it says man as a creature is necessarily dependent upon the laws or upon the will of his creator, or subject to the will of his creator. But a man independent of any other has no rule to prescribe, but such as he, or no rule to pursue, but such as he prescribes for himself. And a state of dependency will oblige the inferior to subject themselves to the will of he upon whom he depends as the rule of his conduct. And that's what it says. And it's because dependency is natural law applied to society creates the jurisdiction of administration. And what I mean by that is you observe in natural law that you are dependent upon God. You cannot exist without God. God created you. God created everything that you need to survive. God beats your heart. You do not even do that yourself. So you must necessarily subject yourself to his will and follow his laws. And that's what Blackstone says, right? But if you are independent of anyone else, you have no rule to pursue but such as you prescribe for yourself. And a state of dependency, if you do enter into that, will oblige the inferior to take on the will of he upon whom he depends as the rule of his conduct. And that's the origin for the state of dependency. And we'll even look, there's warnings in the Pennsylvania Constitution, right? It's the Avalon Project. You go down to section 36, and it tells you right here, as every free man to preserve his independence, if without sufficient estate, ought to have some profession, calling, trade, or farm, whereby he may honestly subsist. There can be no necessity for, nor use in, establishing offices of profit. The usual effects, now offices of profit are essentially poor, the overseers of the poor, welfare offices. Okay, and they're called offices of profit because you're given these they're called wastelands, essentially, right? These poor people who cannot make themselves productive, you're charged with taking them and making them profitable, and then giving them a portion of their profit or their productive value as a benefit. And then, of course, taking a hefty chunk for yourself as an administrative fee. And that's why they said if everyone can survive on their own, they don't need to depend on the government, then there can be no necessity nor use in establishing offices of profit. The usual effects of which are dependence and servility on becoming of free men in the possessors and expectants, meaning the people receiving the welfare become dependent and servile to the state, and that's unbecoming of free man. You can't be free if you're dependent. And that's the biggest thing people struggle with when I try to explain to them how to get out of the system. You cannot be free if you are dependent upon the corporate state. And that's why they spent the last 100 years making you dependent, taking away your life skills, taking away your desire and ability to hunt, fish, right? Farm. Farming's all subsidized and heavily regulated now, right? Not to mention that, but they provide all of these things that make life so comfortable as compared to when we were actually free, when you had to go chop wood to have a fire, right? To stay warm in the winter at night. When you had to go hunt, you had to fish, you had to dig your own well. But guess what? That may have been difficult. That may have took up most of your time, but you were free. And if anyone came on your land, the sheriff, the president himself, unwarranted and uninvited, and you told them to leave and they did not, you can deal with that however you want. And I know how I would want to deal with it. I would take pleasure in it. So it creates dependence and servility on becoming free men, right? And the possessors and expectants of the welfare, once again. And then faction, contention, corruption, and disorder among the people, right? The people are the government, or the people are the ones that are vying to be in that office of profit so that they can basically have indentured slaves, because that's what paupers are. That's what you are now, actually. If you're a 14th Amendment citizen, you're 100% a pauper. So this is how they subvert liberty. This is how they subvert freedom, is they create a state of dependency. And that's what they started to do. This was the purpose of the Industrial Revolution. This was the purpose of creating automobiles that only run on gas, right? Primarily. This was the purpose of creating electricity, indoor plumbing, and all of these things, was to create an entire system of dependence where you're in an artificial womb of artificial reality. It's what it is, right? You need water. You don't have to dig a well. You just go turn on the faucet and it comes out, right? And so as a consequence, these evil scumbags that run this system are like, well, you can't find your own water. You got to take the water we give you. So they put a bunch of crap in it. They poison you and your families. Same thing with the food. You can't get your own food. So guess what? We're going to poison the food we give you. And you're just going to eat it because they hate you. They hate you. They absolutely hate you. So, all right. This is the Pennsylvania Constitution. Sandra Capel said, where is this out of? This is the original Pennsylvania Constitution from 1776. It's from the Avalon Project, which is Yale Law School. Both Harvard and Yale have actually, as much as I despise those institutions, have, probably because they have to, done a very good job in preserving case law and all that. And yes, evil scumbags is an understatement, Jay, for sure. So, yes, it would be nice. We're getting there. Lots of people are awakening to this stuff. Boyd, However, with that being said, shorts, unfortunately, or reels, as it's called on Facebook, just seem to do a lot better than the live streams because people have a tough time sitting down and listening to an entire live stream, which I get. So I cut this into reels and shorts also and get it out there. And hopefully this will be one of them that this will be one of them that I clip. So anyways, right. So the point of, and now we're going to explain the difference between law and equity. And I do know where that is in Blackstone. Now, this is a big thing, and I've been having a lot of people comment on my reels on Facebook about, well, no, equity is the best. Equity is all we have. Wrong. You couldn't be more wrong. That just shows how much they've buried the knowledge of the difference between law and equity. So we'll start this. Before we get into Blackstone, I'm going to show you the Constitution, this infernal document, right? Article 3, Section 2 of the Constitution. It's right here. Boom. The judicial power shall extend to all cases in law and equity. So there's a distinction made, and I'm just showing you how I learned this at first. And that was just the thread I pulled that uncovered the entire scheme of what they're doing and how they're able to usurp the authority of God. So to all cases in law and equity, there's a distinction. Blackstone actually delineates this distinction quite well. So we'll go down to page 59, okay? So let me just 40, 59. Oh, this is annoying. This is entirely different than the book. 57, maybe it's 47, is it? It's got to be 47. I need to get my original books back. 47. Huh. Interesting. All right, we'll do this. We'll go control find equity. Thus, there. All right, no problem. 62 in this copy, so duly noted. All right, equity thus depending, right? Equity thus depending essentially upon particular circumstances of each individual case. There can be no established rules and fixed precepts of equity laid down. Now, what equity primarily is used for, and I'm going to prove this to you, is for adjudicating trusts, disputes arising from trust. All right, so there can be no fixed precepts of equity laid down without destroying its very essence and reducing it to a positive law. And this is the important part, okay, guys? And on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law and leave the decision of every question entirely in the breast of a judge. And law without equity, though hard and disagreeable, is much more desirable for the public good than equity without law, which would make every judge a legislator and introduce most infinite confusion, as there would then be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. This is why the Bar Association likes equity, because they have sole discretion. The judge is God. The judge is Osiris, governing the dead fiction. And equity, because what equity is primarily for is for implied, it's for fiction. It's just that simple. And I'll give you two examples. One, and I'll prove them. One is trusts, because law cannot adjudicate trust, because trusts are fictions. When you breach a regulation of the trust, right? That's not breaking a law. That regulation is fictionally imposed as a law. It's because it could never be a law. It's your own arbitrary rule. But because that person agreed to use property that you have a superior interest in, which is how a trust arises, you can make regulations concerning the use of that property, but to enforce them, you cannot enforce them at law because, well, it's not law. You have to enforce them in equity. And that's where equity gained prominence. The other instance of where equity is used is an implied contract. So say there's a ship and it starts sinking and half the crew jumps off to save themselves. The other half risk their lives, stay aboard the ship to save the cargo. Okay, because they all stood to lose a lot of money. So half jump off, half stay on to save the cargo. When they get to shore, they actually make it to shore. When they get there, the people that jumped off are like, hey, give us our cargo. And the people who stayed on and risked their lives go, well, no, you forfeited it when you jumped off the boat. as if it were an implied contract saying I'm getting rid of this property because if it sinks, oh well. And the people who risk their lives, we earn this as ours now because it would not exist if the boat had sunk. Well, here's the thing. Law cannot adjudicate that because for law to adjudicate that, there'd actually have to be a contract where they agreed to give the other people their property if they saved the boat. And that never happened. So what the people who saved the property are doing are taking an implied trust situation, an implied contract, and they're going to go to a court of equity and say, hey, this is what happened. Now, there was no contract, right? But the simple fact is the cargo would not exist anymore if we did not stay on. And the judge may rule to give them some of the property or, that the others, pay them a certain amount for saving the property or something like that. But law could never look at that situation because there was no lawful basis for the people who stayed on the ship to demand ownership of the property, period. Right? So equity deals with fictions only. We're going to take a look at a book, and I apologize I didn't pull this up beforehand, but it should be easy to pull up. A practical, yeah, that was it. All right, practical treatise on the law of trusts and trustees. Okay, this is an excellent book, by the way, if you want to learn about trusts. Here's the bar pirate that wrote this book, Thomas Lewin Esquire, right? And it's from 1858. So there's going to be a bunch of case citations, of course, in the beginning, if it ever loads, because it's all photocopied. All right. Yeah, table of contents. I should have had this prepared, but I actually didn't even think to bring it up until just now. But this shows you exactly what trusts are and why equity is not a jurisdiction you ever want to be in. Holy smokes. It's a big book. Lots of references, lots of citations. And rightly so, because the guy actually knows what he's talking about. And he's very honest about the trusts. He says the parents of the trust were fraud and fear, and the court of conscience was its nurse. So we're going to start right at the beginning. Let's see here. Section 2. Come on. Chapter 3. We're getting there. Should have had this prepared. It's my fault, but whatever. All right, here we go. The rise and progress of trusts. Whoops, let's back up so we can. So the origin of trusts, or rather the adaptation of them to the English law, may be traced to the ingenuity of fraud. Well, I'll tell you exactly how trusts were introduced before we get into this, and how the feudal system was created in England. William the Conqueror conquered England, 1066, destroyed their system of self-governance. I'm going to kind of gloss over this. I've explained it in detail before. Destroyed their system of self-governance, split the court into temporal and spiritual courts, gave the spiritual court, which dealt with like estates and inheritance and death and all of that stuff, because those are all spiritual matters, to the priest class of Rome. And then he had all the nobles register their property. Now, what does register mean? Regis, to the crown. Register means to give to the crown, to give to the state, right? To give to, regnatum means govern, to be governed. So they registered their property with the crown, with William the Conqueror, and he gifted it back out to them in feudum, right? And now a trust was created. And because he had the superior interest in the property, he could make what could be enforced as law. He could make rules that could be enforced under the color of law. Because if you're using my property and you agree to be in this position, then now you have to follow my regulations regarding the property and the title that you hold, right? So boom, that's how trusts were actually first created. And that's how the feudal system started. See, prior to William the Conqueror, the English had allodial title, meaning absolute ownership, free of any superior claim. The sovereign was the king, which meant that he was the original owner of all the land, but then he would granted out in title, allodial title. And then after he parted with it by allodial title, he had no interest in it. He could not gain any subsequent interest in it unless it is shedded back to him, meaning the owner of the land died intestate, which means without a will. And then if there was no heir or next of kin to take control of the property, then it would have shed back to the king. But after William the Conqueror, he continuously had interest in all of the property and could regulate it. And that's how trusts originally were created. And the feudal system. We live in a neo-feudal society right now. And so, because right now, that's the corporate state has a superior interest in all the property, and they charge you rents and fees for the use of it and for the misuse of it. That's what property taxes are. That's what licensing and registration are. That's all that stuff is feudalism. It's neo-feudal, 100%. And it's right out of William the Conqueror's playbook. So they registered the property, gave it to William. William then gifted it back out in feudum or in trust under title. And then the barons and the knights and all that, they would grant parts of it out in trust to tenants, peasants, and stuff like that, right? And then that's why a tenement is something you would inherit. You have the right to live on this lord's land that you inherited from your father. You inherited the trust. And that's actually all laid out in this book as well, and in Blackstone's, and in a treatise on the American Law of Administration, which we may take a look at. You know what? I might open that real quick just so it can load while we're looking at this, because that thing is a huge book and takes forever to open. But here it is. And we'll go back to this one. All right. So says the origin of trusts, or rather the adaptation of them to the English law, may be traced to the ingenuity of fraud. By the interposition of a trustee, the debtor thought to withdraw his property out of the reach of his creditor. We'll see through the imposition of a trust, right, or through the interposition of trustee, they've actually, and presumption of incompetence and pauperism, they've taken control of your sovereignty. That's why they wanted you to have the sovereignty in the beginning. That's why we were free in the beginning, so that they could then reduce you to some sort of infant ward under administration, which is what the 14th Amendment does, and then take and use your sovereignty on your behalf, because a corporation could never have sovereignty. But if it's administering your estate, it can use your sovereignty on your behalf, essentially. So, and taking it from you because you're incompetent. So the freeholder to intercept the fruits of tenure from the lord of whom the lands were held, and the body ecclesiastic, meaning the Roman Church, to evade the restrictions directed against the growing wealth of the church by the statutes of mortmain. Now, an interesting thing, this also leads into why trusts and corporations were created and developed to this present day, and why they're taking control of the world, is because the reason King Edward issued the statutes of mortmain was because what was happening in England is people would die and then they would leave their lands to the church because they were Catholic, right? Well, it was just Christian at that point during King Edward. There was no Protestantism at this point. But anyways, they were Christian and they would leave their lands to the church. Well, the problem with leaving their lands to the church, and King Edward, though he's painted in a very poor light in Braveheart, he actually, I think in a lot of respects, was a very just king. Not with what he did to the Scots. That was evil and cruel. And I'm actually Scottish by descent, so I'm not like lauding this guy or anything. But what I am saying is that to his legal mind to be able to see this, it was very astute. So he's seen what the church was doing. The church does not die. Okay. The church does not have heirs. It has successors. It is a perpetual, never ending trust is what the church is. Corporation is a first world corporation. So if people in England continue to die and leave their lands to the church, what would happen? Well, eventually the church would hold all the lands in England and would have effectively usurped the kingdom. And so he issued the statutes of mortmain. So then the church created the concept of charitable trusts to hold and maintain lands on their behalf, right? So they were not directly holding them or using them, but they were the beneficiary of the trust, right? So they weren't holding it, but it still was under their control. Anyway, so down here, this is how you know that you're in purely equity. Now, trust can only ever be adjudicated in equity. This is well-established maxim. of both equity and law. Trust can only be adjudicated in equity ever. Don't believe me? Look it up. It doesn't even bear me showing you because that's 100% a fact. And the way that you know that you're locked in equity, aside from me absolutely proving it like I'm about to, is they summon you to court. Okay, so let's read this. Originally, the only pledge for the due execution of the trust was the faith and integrity of the trustee. But the mere feeling of honor, proving as was likely when opposed to self-interest, and extremely precarious security, what that means is people's word, an individual's word doesn't mean shit. That's what that means. Excuse my language, but that's what he's saying. He's like, okay, it's real precarious when you could stand to profit from screwing me over. We need some way to compel your performance. So what happened was John Waltham, Bishop of Salisbury, a chancellor in the reign of Richard II, originated the writ of subpoena. This is where the subpoena comes from. And notice they don't use subpoenas really anymore. It's just summons, because that's what a subpoena essentially is. But a summons, because you no longer have any kind of access to law whatsoever. You're an entirely dead entity. You're legally dead because you're a pauper and you're bankrupt. It's called civiliter mortis. Okay, look it up, civiliter mortis. When you're bankrupt, you're civiliter mortis. When you have no access to lawful money, you're civiliter mortis. You're civilly dead. So they summon you. And it says the subpoena by which the trustee was liable to be summoned into chancery and compellable to answer upon oath the allegations of his set decay trust. Now, right here, that's what they're doing when they call you into a courtroom. See, you are the trustee of your own property. When they summon you into a courtroom, it's usually for a presumed breach of this trust. So the administrative regulations, since all of your property is held in trust as collateral for the public debt, these administrative agencies have been endowed with regulatory authority over areas of public concern, like the DMV over motor vehicles. And they issue the motor vehicle code. That motor vehicle code is the regulation of your trust indenture concerning that piece of property held in trust as collateral, the motor vehicle, right? Which is presumed to be commercial, all that. I'm not getting into that right now. I already have ad nauseum. And so when you breach that trust by violating the motor vehicle code, they issue a summons to compel you to come into court and answer upon oath the allegations of the set decay trust, which is the estate. Right? Because you're not the owner or the heir of the estate. You are just chattel property of the estate. See, that's how they do this little double-minded thing. It's you as the living man or woman are presumed to be dead. You're beyond the sea, right? And our documents laying that out here, they're not the Set Decay V Act. It's called the Uniform Disposition of Unclaimed Property Acts. Look into those, right? And so you're considered missing, presumed dead. Now, you as the U.S. citizen are merely like as if the estate, when the owner went missing, had an indentured servant as chattel property of the estate. Well, that's you as the U.S. citizen. You're just chattel property. And so you're being compelled, right, to answer under oath the allegations of the Set Decay Trust, which is the estate. Now, what's interesting is, let's look at the word. Well, first here, let's cover this real quick, just to tie this off. So he says right here, thus, in the words of an old counselor, the parents of the trust were fraud and fear, and a court of conscience was the nurse. Well, what is a court of conscience? Court of conscience is a court of equity, right? If we look at Bouvier's Law Dictionary, we'll go to Bouvier, letter D, and we'll go down to discretion. Okay, we want to look at discretion. It's very important because that's what the judge has, sole discretion in a court of equity. And Bouvier is about to tell you exactly that. Okay, it's right here. Discretion. Practice. When you see something that says practice, it's the practice of law, right? So it says, when it is said that something is left to the discretion of a judge, it signifies that he ought to decide according to the rules of equity and the nature of circumstances. Okay, right? So you're going to hope he's fair. Well, what has experience taught us? I don't know. Bouvier, take it away. The discretion of a judge is said to be the law of tyrants. It is always unknown. It is different in different men. it is casual and depends upon the constitution, temper, and passion. In the best, it is oftentimes capriciousness. In the worst, it is every vice, folly, and passion to which human nature is liable. That's equity. So that right there, right, the discretion of a judge, that's what Blackstone's talking about right here when he says, lest thereby we destroy all law and leave every decision of every question entirely in the breast of a judge. Equity without law is essentially an idiot without a compass to know which way to go, right? That's it. The judge is an idiot. He thinks he's the compass. He thinks, oh, I know better. That's why judges hate when you bring up God, because he's not using those guide stones, the principles of the Bible and natural law to guide his decision making. And he wants to do that because that's the point. He wants to be God. He's a scumbag. He's a pirate. There's no other way. That's why he wears a black robe. He's a satanic piece of garbage, right? And so he says, leave every question entirely in the breast of a judge. And he says right here, which would make every judge a legislator and introduce most infinite confusion, as there would be as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. So through the absolutely unlawful ratification of the 14th Amendment, because it violated Article 5, which I've gone over this ad nauseum, and United States citizenship is 100% voluntary anyways, but the fact that people did not know that caused them to continue to use it. If you pull that Jenga piece out, the whole thing falls. But because of what the 14th Amendment is created for the newly freed slaves who were dependent. They had not yet learned how to be independent, as Andrew Johnson says in his veto message of the Civil Rights Act. He says the avenues of freedom have just opened to the black man, right? He says, and in time, he'll learn our institutions and our laws, and then he can exercise common law rights. But right now, he's in a state of dependency, right? And so the 14th Amendment purports to offer privileges, immunities, benefits, and protection for these newly freed slaves in exchange for their autonomy, which is given away by the fourth provision of the 14th Amendment, which is 14th. I was hoping it would just come up, but here, we'll look it up anyway. 14th Amendment right here. Go down to the fourth section. The validity of the public debt of the United States shall not be questioned. Well, what does that have to do with granting privileges, immunities, and benefits and protection? Or is it more to do with the fact that the federal government was given the sole power of controlling the currency, right, and not the states, and therefore to establish a central bank, the federal government wanted to have its own pool of collateral. Oh, yeah, that makes sense. That's exactly what the 14th Amendment was about. And because of the dependent nature of the 14th Amendment requiring daddy government to give you privileges, immunities, benefits, and protection, you automatically, by operation of law, come under administration. So they do have the ability to mortgage your estates as collateral for the public debt, because they essentially have power of attorney. They have administrative control and fiduciary authority over the estate. That's exactly why that happened. So let's see. They've locked you into equity. Once they caused everybody to adopt the, just trying to see if I can still find that creature part. It can't be that far back. But anyways, once they put the state citizenship into disuse and buried, until the internet became a thing, and now with people like me having gone through and dug and found these cases and made it well known that there are a plethora of Supreme Court cases that show that not only is 14th Amendment citizenship voluntary, but it's actually an inferior status. Like, let's take a look at this. Maxwell v. Dow. It's from 1900, okay? Right here, citation 176 U.S. 581, okay? That's all the citation you need. You can find it right here in Harvard Case Law Access Project. So go down here. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Wait, what? The Bill of Rights doesn't apply to 14th Amendment citizens? Well, why do people always go into court and say, I have the constitutional right to this and right to that? No, you don't. You only have privileges and immunities legislated by Congress, which can be changed at any time and taken away as well. Okay. Here, I'm going to minimize this. We're going to go to another page real quick, or not minimize, but remove this. And we're going to pull this up here. And I'm going to share this screen. I'm going to minimize this because I've got a plethora of cases over here. All right, share. Yeah, I don't care if my update's complete. Anyways, we have not Santa Clara, Maxwell v. Dow, ex parte nulls. Just got to find it real quick. Elements, please, yeah, this one. So this is Cross v. Board of Elections. Okay, this is from 1966. Right here, this is where a guy was running for the office of sheriff, but he was not a U.S. citizen. As late as 1966, everyone, I hope you hear this. He was not a U.S. citizen. He was just a state citizen, right? And it says, in the instant case, it was held that the appellant who has been a resident of Maryland for more than 5 years preceding the election was qualified to become a candidate for sheriff of Baltimore City, although he was not a United States citizen for at least 5 years preceding the election. It says the court stated that there is no express requirement in the Maryland Constitution that sheriffs be United States citizens. It says that down here, we're going to go a little bit further. It says it has not been. Okay, here it says it was pointed out that both before and after the 14th Amendment to the federal Constitution, it has not been necessary for a person to be a citizen of the United States in order to be a citizen of his state, lowercase s state, because that's the original de jure common law state. The word citizen is capitalized, supposed to be when you say state citizen. Okay, now over here, it says in conclusion, let's see where we're at right here. I just seen the word conclusion out of the corner of my eye. Where's it at? Court stated that the conjunction constitutional domicile for citizens noted. In conclusion, okay. And in conclusion, the court stated that it found nothing which requires that a citizen of a state must also be a citizen of the United States. That citizen of the United States is a trust office. And even worse than that, it is a creature. The federal corporation is the lowest entity on the totem pole. It goes people at the top, create the state, right? And the state's subject to the people. And then the state got together and created the federal government, which is subject to the states, except for those powers expressly granted to it via the Constitution, originally the Articles of Confederation. Then the United States, the federal government, created its own creature called the 14th Amendment citizen, which owes its existence entirely to the 14th Amendment and to the United States, is not allowed to question the public debt, and has no constitutional rights whatsoever, no common law rights. Is under administration by virtue of being a ward of the state, because daddy government protects you. Remember, that's the whole point of the 14th Amendment. You're a ward of the state. You're under administration, and you hold all of your property in trust at the discretion of Congress and the president. That's it. So, inevitably, what happened once they got U.S. citizenship to be prevalent enough, because everyone is now locked in a trust indenture and a trust relationship with their own property with only the right of use according to however administrative agencies determine you should use it, they could abolish the distinction between law and equity. And effectively, they didn't mix them. They just buried law and removed your access to it, because in order to access law, you have to have lawful right to your property, meaning you have to have bought it with lawful money and no one else has an interest in it. And then you can go to a court of law and assert your rights. But you now only have equitable interest in even your own person, your own self, your own body. That's why they can tell you not to do drugs, wear your seatbelt, right? Seriously, that's so. You do not even have autonomy over your own body. You only have your body, your free will is held in trust as collateral for the public debt and subject to administrative agencies. And so by 1938, it says, just as the 1938 rules abolished the distinction between actions at law and suits in equity, which is impossible unless you've created a national trust where no one has access to law, which is what the creation of the Federal Reserve Note did, right? Because we read right here, in 1933. Oh, wait. Yep, it's right here. Okay. March 9th. This is House Congressional Record, straight from congress.gov. Government printing office right here. You can see in the address. Got it right off congress.gov. It says the money will be worth 100 cents on the dollar, and it's just on the left side of the divider. So maybe in order to not confuse people, I'll zoom in a little further. So it says the money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. A mortgage on all of your property. Well, how can they do that before you've acquired it? Because it's actually the mortgage of your estate. So, of course, I'll prove that, because I know how particular people can be and how they want to act like I'm missing something or whatever, with even though I've done years and years of research into this. Let me see if I have it open first. I'm looking for it. And if I do not, then I'm going to open it. It's called Fiduciary Foundations of Administrative Law. It's by a law review or a law student named Evan J. Criddle, right? Fiduciary Foundations of Administrative. And it makes me type in almost the whole thing before it brings up. It's kind of annoying. Actually, it's making me type in the whole thing. Now it popped up. How about that? All right. Right here. So it tells you the emerging fiduciary model. Now, for those of you who do not know what a fiduciary is, a fiduciary is a trustee capable of making financial decisions on behalf of the trust. So these administrative agencies, and particularly courts, are acting as fiduciary trustees in regard to your estate. And the judge is attempting to be an administrator. So it says the fiduciary model in administrative law posits that in administrative agencies, what are administrative agencies? Those are your DMV, your IRS, your ATF, your EPA, CDC, FDA. Those are administrative agencies. They're not even governmental. They're private corporation. Well, I'm sorry. They're government services corporations. Okay, but they're still not even government. They're just endowed, as it says right here, are endowed with authority to set regulatory policy. Well, what is regulatory policy? Well, this would be the health codes, the food codes, the motor vehicle code. So this is the regulation of the property that was mortgaged in 33, right? And it says they gain this authority when Congress and the president, acting jointly as proxy settlers for the sovereign people. Proxy settlers for the sovereign people. Well, now that's got to be confusing to some people, right? So we'll go here. We'll look up, let's go Bouvier's Law Dictionary, letter S. And now we're going to go down to settlement. Okay. Right here. Settlement. The conveyance of an estate for the benefit of some person or persons. This is why they call the certificates they issue to paupers. Everybody knows about the settlement certificates in England. Very few people know that they immediately began doing that here to take people under administration. Settlement certificates, when something is settled, that means the estate, the entire estate, which an estate is essentially your right to property, right? It's your interest in property, is conveyed to the person giving you benefits. It happens naturally by operation of law. And in this instance, it happened naturally and was recorded in congressional record. In order to create Federal Reserve notes, since the U.S. was bankrupt and broke, had no lawful money, but you have to continue to engage in commercial activity. So we now entered a fiat debt currency system secured by your own sweat equity and that of your children. And by operation of law, your estate was mortgaged. Okay, that's the scary part of it. And so it's the conveyance of an estate for for the benefit of some person or persons, right? And so that's what they mean when Congress and the president acted jointly as proxy settlers, as we clearly see they admit to right here in House Congressional Record, March 9th, 1933. Ryan, you have to remove your dependency from the state entirely. That's what you have to do. So that's why people who are tricked into going to college, I feel bad for them. If you learn a trade, just like it said in Pennsylvania's original constitution, you are the value. You can barter your skill for food. You can barter your skill for clothing. You can barter your skill for whatever. And as I was talking to one of the members of the Jurist Society yesterday, the idea would be to create a network of people who are interested in bartering for their everyday necessities outside of the Federal Reserve System, right? You know, a mechanic, right? Maybe whatever your skill is, you trade your skill for the mechanic, you trade your skill for the farmer, you trade your skill for the baker, whatever the case may be. And in reality, you know, anybody can learn how to do these things, but certain things, which we call trades, generally take a long time to learn. So you have to have some sort of inherent value in the first place to be free, which is the point. If you have no inherent value, then you're a pauper. The inherent value, I mean, is some sort of skill or profession or calling, right? Or farm where you produce and you do not just consume. And that's another reason why they hate you. They call you consumers, useless eaters, but in ignoring the fact that they engineered you to be this way. And by you, I mean society in general, not the people watching, but, and maybe some of you, I don't know you personally, but, you know, still at the same time, what I'm saying is this is how it happens. So back to the cases that prove U.S. citizenship is, and this is why we challenge the 14th Amendment, because they could only ever do this to 14th Amendment citizens. They could never do this to the people of the states. That's why the 14th Amendment, that's the true purpose of the 14th Amendment. And that's why it says in the 4th section, the validity of the public debt shall not be questioned, right? So that's the 13th Amendment. And then we'll go to 14th right here. That's why this gives away the entire intention behind this. The validity of the public debts, the validity of the public debt of the United States shall not be questioned. What kind of crap is that? Well, I'll tell you why. It's right here. This is why, because once they did this, they wanted you to not ever be able to question it, but they could never do it to the people of the states. And as we've seen, there is a distinction right here between United States citizens and state citizens. Now, the distinction's further laid out right here in McDonald v. State. Right, it says that although he was not a citizen of the United States, he was a citizen and voter of the state under Section 2 of Article 2 of our state constitution. One may be a citizen of a state and yet not a citizen of the United States. Period. And this is Indiana Supreme Court. All right, so now we have Maryland, Indiana, and the equal footing clause tells you that even if no Supreme Court case in your state has ever actually put this into a citation, the equal footing doctrine, Article 4, Section 2, makes it the case for every state. All states are on equal footing. They entered the Union on equal footing with the original 13 states. So even if it was after the 14th Amendment was ratified, your state was created, you still don't have to be a United States citizen. Nor do you want to be. So you're trapped in equity. That's where we're at right now. And the judge gets to play God. Now, where are they going with this? Well, they want to make it permanent. See, somebody like me can enter into the courtroom and right at arraignment challenge jurisdiction by asking questions. Is this a civil court or a criminal court? In fact, I think I'll show you an excellent video of someone who does just that. And until we actually get enough people to wake up and realize why we have to cast off the chains of this current government and go back to something that that constitutes our peace and happiness and freedom, most importantly, right? Even if it's not peaceful, because keeping your freedom isn't always peaceful. Thomas Jefferson said the tree of liberty must be refreshed from time to time with the blood of patriots and tyrants alike. Because if it's not refreshed, and this is me speaking now, if it's not refreshed, then that tree dies. The tree of liberty dies. Because tyrants will never not exist, and they will never stop coming to enslave you. These wealthy, megalomaniacal, aristocratic oligarchs will never be satisfied until they have dominion over the whole earth and all of the people in it. That's a fact, right? So I'm going to show you guys a video, show you guys a couple videos, and we're going to talk about a couple more things as it pertains to where we are today. And never forget that the Bar Association, let's talk about this real quick. The Inns of Court created the Bar Association. What are the Inns of Court? Well, the Inns of Court were established in England and patronized by the Knights Templar. Okay, The Knights Templar, also known as the Poor Knights of the Temple of Solomon, were very interested in Solomon's wisdom. What was Solomon's wisdom? Well, I guess we'll never know, but I would bet that it has something to do with converting the idea of good and evil into a system of credit debt, which is pretty much the same thing. Sin is debt, right? Credit debt. And then creating an art, making an art of turning promises into currency and using that to indenture the world, to gain administrative control over people in order to give themselves the ability to make rules and enforce them under the color of law. Now, if you guys have never seen the doors of the Bank of England, and if people do not realize that money and law are intimately intertwined because all law is derived from property, and your relationship with your property determines the law you're under. I'm trying to find where I pulled that up. Boom. Your relationship to your property determines the law you're under. In fact, that relationship is called status, which is Latin for estate, right? And so if you're not the lawful owner of your property, your estate, and you only have equitable interest in it, well, then you're not sovereign. You are under administration. This is the doors of the Bank of England. You have to look at how the bar associations and the Rothschild banks have worked in tandem, right? Who creates the, what, okay, so what is a Federal Reserve note? It's a promissory note. What is a promissory note? It's a contract. Who drafts contracts? Lawyers. Lawyers do. Who created the legislative frame? And I'm sorry, not lawyers, attorneys nowadays, right? The bar members, the esquires do, right? Who created the legislative framework necessary for the central bank to be established in the first place? Esquires. Where is this bank? The same place the Inns of Court are. These people serve the devil, right? Communism is perfected feudalism. The bar associations are communist guilds, and they are trying to centralize the control of all property under a New World Order corporate oligarchy, using debt to indenture you and take control of not just your property, but your rights to property. Your rights to property. That's the thing about it, right? A scary thing about it. Look at this. This is something talking about the Inns of Court in Australia. I want you to notice something. I don't know if you guys can see this or not, but when I pull this little tab up here at the top, and it's a black cube that's next to innsofcourt.com.au. It's a black cube because it's the black cube of Saturn. That's who controls these people. That's the entity that controls the Inns of Court, that control all the demonic minions called bar members, right? So in the position we're in right now, we cannot do anything. There is no remedy. You're not going to appeal to a higher court for remedy, okay? Here, I got to stop this for a second while I find this reel. You're not going to appeal to a higher court for remedy because they're all controlled by the bar pirates, okay? And I'm going to show you something in a moment after we watch this video that will further illustrate this is exactly the only way we can fight them. You're never going to have a recorded win in court. You're never going to set precedent in an appellate court or in the Supreme Court because they will not allow it. What they will do, if you're good at what you do and know how to challenge jurisdiction, they will throw it out so there's not ever any record of it. And I have an example, probably one of the best examples I've ever seen of exactly that. As soon as I find it here. Let's see here. I didn't think it was that far back. Let's see. Well, we'll just do that. Saved items. This guy's name was, and a Rubik's Cube. Where the hell is this? There it is. Sorry about that, guys. Here, let me pull this up, pause it, and I'll share the tab with you. You guys are not going to want to miss this, so be patient. It's an afterthought to even present it. You have to listen close, turn the volume up on your device that you're watching this from, because I believe this file has been corrupted, and you'll see why, and the audio is not that good, but you will appreciate this if you've never seen it before. So let's make sure we have sound. And I will pause it to clarify what he's saying because I know it's hard to hear. All right. They're calling this guy up. So she just asked him if you're able to cure your license with the DMV.
For the record, my name is Ryan Thor. I'm the living man. I am not the entity known as Ryan Michael Thor, just to clear that. I am here on special appearance under threat, duress, and coercion to challenge subject matter jurisdiction and also personal jurisdiction as well. I filed my paperwork for you on Friday, and the clerk illegally denied it. I went again this morning and filed my paperwork again for you. The clerk again illegally denied it, even though I gave her a notice telling her it's a felony for her not to accept my paperwork. And actually, it's in law, it's considered filed when I gave it to her. Okay. So there. What do you want to do today, sir? Well, Your Honor, I mean.
So she just said, what do you want to do today, sir?
I'm going to have to ask a few questions first, which first of all is I need to understand the nature and the cause of the charges against me, as well as I need to know, is this a civil jurisdiction or criminal jurisdiction?
Okay, it's criminal jurisdiction.
Criminal.
So she said it's a criminal jurisdiction, but there's no, there's no jail time because it's traffic, is what she says.
Traffic infraction court, so no possibility of going to jail on any of this.
And see that gold fringe flag up there, right? And that's why it's criminal, because motor vehicles defined in Title 18, which lays out crimes and criminal procedure, specifically under special maritime territorial jurisdiction, which is Title 18, Section 7 of the United States Code. And so it's a very good question to ask right there, right? She says criminal. Okay, boom, I got you now. I have you.
Settled one of your counts. You just proof of correction on August 26, 2022, or Ryan Michael Thor did. Are you saying that's not you?
Ryan.
So she just asked, she said, or Ryan Michael Thor, said something about settling an account, this and that, on a date, and then said, or Ryan Michael Thor did. Are you saying that's not you? Right? Are you not him?
Thor is the living man. Ryan Michael Thor is the defendant in error. It's the artificial person. So thank you, Your Honor. Let the record of the court show that the action against me is criminal. And now I have another question, because the Constitution grants us two different criminal jurisdictions, okay? One criminal jurisdiction is under the common law, and the other is under the criminal jurisdiction of admiralty or military tribunal venue from Article 1, Section 8, Clause 17 of the Constitution.
It's actually not Clause 17. The maritime tribunal under Congress is Section 10. And what this is an administrative tribunal under Section 9. Or Clause 9, I'm sorry. So it's Article 1, Section 8, Clause 9, and Clause 10, not Clause 17, but that's okay. You still did a great job.
Can we come back to your case in a second? I got to do some other cases, and then I'll take the time to do all this with you.
Well, I need to know which of these two jurisdictions that.
So what she just did was try to push him to the end after all the other cases, because already he said too much and she doesn't want. This is the only way you can beat these people. You'll never have an established win in these bar-controlled courts. You have to know how to stop them in their tracks, because even though they are pirates, they still have to follow the law. Remember, all of man's statutes and codes that are of any force, as Blackstone says, have to be traced either immediately or immediately back to the one and only law, not written by man. That's Blackstone's commentaries, not me. He says that, right? And I agree, obviously. And so they need you to consent, because the only thing they can trace back to the law is your free will and consent to be in this artificial structure of trust, indenture, right? That's it. So they have to acquire that jurisdiction. And so she just tried to put them to the end of the entire docket after everybody's done and gone, so she can deal with them and do what she's going to have to do anyways, right? Watch this.
You intend to try me. It's very important, because they're done different ways. The rules of civil procedure are very different in a criminal jurisdiction, obviously for common law, and a military.
No one's asking you, no. So we just need to show, were you able to cure your license with the DMV, or you don't know?
So she asks a question again because she doesn't want to answer. And this is why you always ask questions. I just made a reel/short, depending on which platform you're watching it on, about challenging jurisdiction. And you always ask questions. So because you put the burden of proof on the other party, she asks the question back. Were you able to cure your license with the DMV? If he does anything other than answer with a question, again, challenging jurisdiction, he has consented to be the trustee of this constructive court trust that they've created, right? So he does.
Your Honor, I need to get these other questions answered. I need to know what the jurisdiction is, and I need to know also who the injured party is. The nature and cause of this. I need to know who the injured party is. I need to know who's bringing the claim.
How about, okay, the state is, so here's the deal. Do you want to have a trial date? I can give you many trial different dates, and you come in and you can ask all the questions, and they have to prove the charges.
So now she's trying to get him to agree to go to trial. And Joe the Ho, you can disagree all you want, dude. I'm not making this up. They actually have to follow procedure. They have to get your consent and to acquire jurisdiction. That's it. They have to do that because it all goes back to the spiritual fundamental origin of the law and the fact that there's a reason this lady's wearing a black robe, which again, as Lewis Smith pointed out earlier, is also against the natural law, but whatever. Right. So anyway,
thank you, Your Honor.
She tried to get him to agree to go to a trial because if he says, okay, I'll argue this at trial. Well, now he's going to be arguing in equity, right? He's going to be disputing the case in equity and the judge gets to be God. No, you stop them in their tracks, challenge jurisdiction. No, we're not going into equity. How could you have me in equity? Am I the trustee of some undisclosed trust I do not know about? How is this possible? Right? So watch this. He crushes it.
But I don't think you'd be violating your oath of office by doing your duty under the Constitution. Okay?
Mr. Thor, I'm going to have to come back to your case because I have all these other cases and I'll take all the time in the world to do because you Adam today?
She is desperately trying to get him to shut up and wait till after everybody leaves.
Your Honor, I just motioned for dismissal because if this is a criminal jurisdiction, as you're claiming, I need to see a verified complaint and I need from the injured party, and I have to have an opportunity to face my accuser, as you mentioned at the beginning of this entire hearing. So who is the injured party? That's the question. Who's the injured party? Why am I here? I don't understand why I'm here.
So absolutely crushes her. And now she's trying to figure out what she's going to do. Now, here's another aspect of this, and the reason why the court has, and we'll watch the end of this because it's important. It's going to illustrate what I'm about to tell you. There's a reason the court has a 99.9% victory, ratio in their prosecutions, and it's because when all of this is commercial, just like it says on the screen, right? All crime is commercial because it's all breach of trust under commercial equity. So all crimes are commercial, and the reason they are is so that the court can act as a bank, which is what a bench is, and generate its own commercial paper from the debt obligations created by the road pirates who cause injury for victimless offenses on the side of the road. That traffic ticket is a security, a debt security that they then bundle together and sell to institutional investors. So now that debt's already been created and sold, right, packaged and sold, because they're like an efficient clockwork, somebody's going to have to cover it. And it's 10 times the amount of the original ticket, right? So somebody's going to have to cover it. They do not want to cover it. And you'll watch how she tries to cover it, even though she has to dismiss the case. Watch.
All right, sir, I'm going to just exercise my discretion. I'm going to dismiss count 1 and dismiss count.
So she just said, I'm going to exercise my discretion. Again, equity, right? As she has all the discretion. There's no jury, no nothing. Exercise the discretion, dismiss count 1 and count 2, and watch.
And just order the fees that you've already paid to cover court costs.
And order the fees you've already paid to cover court costs. Yeah, because you already made that security. You already generated that security, and somebody's got to cover it. All right, so watch him. He goes, no.
Okay.
So
No charges are pending against you. They've been dismissed. Interest of justice.
So I'm letting the record show that
She said there no charges are pending against you. They're dismissed in the interest of justice. This is what they say when they dismiss it too, in the interest of justice, which really means in order to not disclose the scheme that's actually going on here in front of everybody, we're just going to get you out of the courtroom. This is the only way you win. This is the only way that you will ever win against them. And this current system, bar controlled, until we get enough people to learn the law and learn why they have not only the right, but the duty to abolish this system. Right? It is international. It is the largest system of trafficking ever created and perpetrated in the history of mankind. It makes what Rome did look like child's play. Nothing. Rome can't even compete. I mean, of course, it is still Rome, but I'm talking about ancient Rome, right? Because the judges are governed by canons, after all, and probate or administrative law is all, the word ministers and the word administers always been under the church since William the Conqueror. So that's another reason why she's wearing a black robe, just so you guys know.
That the defendant, Ryan Michael Thor, with case CMZ 606-406, all charges are dismissed. Is that correct?
And whatever fees were paid are going towards court costs, okay?
And whatever fees were paid are going towards court costs. They do not want to cover that debt. Watch.
Well, those fees are bail, and they should be returned after dismissal.
Okay, you know what, I don't have a problem with returning your fees. I know.
Thank you.
She immediately gave up that one. She said, you know what? All right, I have no problem giving. Yeah, because what would you even, how would you even justify keeping those? What, like I just donated money to the court? There's no charges pending. There's no case. I was never found guilty of anything. How the hell are you going to try to keep my money? It's insane. She doesn't even put up a fight. She's like, okay, you asked for him back. Damn it. You're going to have to eat these costs. She probably got in so much trouble for this too. So much trouble for this, right? So you guys have seen it. I'll link it in the YouTube chat, and then I'll put it on Facebook and Rumble in the comments after the stream is over, because through StreamYard, I only have access to the YouTube chat for some reason. But there you go. You guys can watch that, share it for yourself. I'll put it on in the comments after the stream on Facebook and Rumble. And let's move on. So a couple more things I want to cover. Share the window again. So why I said these, and I've said a couple times during the stream, that these attorneys are not actually lawyers, and they're not. They're attorneys. And what is attornment? Well, attornment is the act of a feudatory, because I told you they set up a neo-feudal system via the trust indenture in the 14th Amendment. It's the act of a feudatory, vassal or tenant, by which he consents upon the alienation of an estate to receive a new lord or superior and transfers to him his homage and service. That's the name in all caps. You literally, the attorney is there to transfer your homage and service to the court or to the judge as a special administrator. And you agree to execute the terms of the constructive trust he just created, or the court just created, because the clerk actually does it. But that the court clerk has created. And that constructive trust is your all caps name and the docket number. Okay, now that's not necessarily the United States Citizenship Trust. It's the court trust. And you're actually being employed by the court to do business with essentially yourself. And that's how they avoid the unjust enrichment clause, right? So they take a portion of property from the estate, i.e. you, the chattel property, the trustee, and they transfer your homage and service from the original estate in the United States to this the special administrator in the courtroom, right? That's what attornment actually is. Very, very important to know that. They're not actually lawyers at all. You could consider, I mean, got to be careful what I say on social media, but anybody who studies the law is a lawyer. Now, here's an interesting little thing too. Templar. Anybody who studies the law and is actually adept at being able to practice and teach it anyway. So what is a Templar? Very first definition in the 1828 dictionary is a student of the law. Of course, this calls back to the Knights of the Temple, and then, of course, which are now the Inns of Court, which makes this definition even more important, Esquire, because that's what the attorneys are. They're little bitches of the night, right, who hope in one day to be a knight, right, as Chief Justice John Roberts now is a member of the Middle Temple, and he's a Chief Justice, which is horrifying, right? So I was going to get into the actual entire document of silent weapons for quiet wars, because where I want to kind of go from here, and I'll pick up this on the next public stream actually, but I'm going to show you guys a video. That's and I'll find it here in a moment. But the entire purpose of every conspiracy, as I've said, of what are called conspiracy, and really conspiracy just means a plot to do something, you know, a plot by two or more people to do something unlawful. That's a conspiracy. So doesn't mean fake, doesn't mean, you know, made up or crazy or loony, like the CIA has engineered into society to think it means. And they've done that through the media. That's actually, there was an entire book written about it with the CIA memo that went out to the newspaper agencies in it saying, hey, you need to use the term conspiracy theorist and you need to relate this term to the words nut job, wacko, lunatic, psycho, unhinged, and all this other stuff, and constantly sow that seed in the media, which then Hollywood and the mainstream media picked up the mantle and they started doing exactly that, even in, you know, movies, even in kids' movies. Yeah, oh, you tinfoil hat wearing, you know, all that stuff. Because if for some reason, all throughout history, right, the people knew that the government was the beast that must be chained, right, that necessary evil. And then all of a sudden, in the last 100 years, it's like, what, you question the government? What are you, some kind of conspiracy theory? Dude, they would never do anything against our interests. They're only there to serve us and protect us and keep us safe. Dude, absolutely not. They want you gone. They want you out of here. They want a small, manageable slave population. And then AI is going to run everything else. That's how that's actually going to work. Okay. So what I'm going to do here, bear with me for a moment, is I'm going to pull up this video. It's called Silent Weapons for Quiet Wars, because ultimately all conspiracies, what I'm getting at, are aimed at subverting the law and creating a worldwide neo-feudal, technocratic, and communist system to permanently enslave you, lock you in equity as the trustee and chattel property of your own estate, eliminating your ability to challenge jurisdiction. They want to eliminate your ability to challenge jurisdiction because, just like we seen at the video at the beginning of the stream, the lady, well, you went 5 over the speed limit. 75 credits are now deducted from your digital wallet. You don't get to, you know, state your name for the record. Hey, I'm here by special appearance and I need to know the nature and cause of the charges against me. That's what they're trying to get rid of. They do not want that to happen anymore because of the video I just showed you guys, because it will win. They need to acquire that consent jurisdiction. Yeah, like Ryan says, why would they lie? Right? They need to hire that consent and jurisdiction. And if they're able to establish AI governance, digital currency, and digital ID, everything will be linked into one master file under the direction of artificial intelligence. And it really will be that way. So there'll be no due process, no opportunity to challenge whether or not these administrative regulations even apply to you, because we are the people of the states are truly sovereign. In fact, to answer the question, even though she probably won't see it, somebody asked me in the comments from Sweden, it says all political power are derived from the people, but we live in a communist country over there in Sweden. That's because all governments are created at common law. The very first compact or agreement that creates a system of government has to happen in the jurisdiction that is unwritten by man, and that's common law. That original agreement has to be a common law contract, right? So no matter what country you're watching this from, if you go back through your laws, originally you were sovereign. Unless they've removed, but see, they can't remove the law because it builds on itself. It always has to be traceable back to the original law. So even in Rome, once upon a time, but what happened in Rome is they came up with the legal philosophy that, well, natural law or common law is unfit for humanity because of their free will and their you know, the wickedness that exists within them. So we must have some system of justice that's called civil law, where basically everyone's reduced to property held in trust and under the administration of daddy government. And that's what they've implemented here. That's why we have the Roman eagle on our money. That's why we have the Roman eagle on our seals, right? That's because it's still Rome, and it's still about reducing you to property and administering you as property, right? So that they can enforce their arbitrary rules and regulations, statutes, codes, whatever you want to call them, under the color of law. Because the only way anything but law applies to you is either if it's in accordance with law, like somebody makes a statute that says do not murder, right? Or if you agree to be in that position, and you have to agree to be in that position. You have to. It's the way it works. The original jurisdiction was not created by man. That's it. It's recognized by man. So this is a video I'm going to show you guys here. from a content creator who goes by, well, he's Matt Schneider on Facebook. He puts out a lot of good material, and he's all for freedom. You may have come across him on X. I recommend you guys give him a follow. And this is a video he put out, and this is what we'll get into next time, because this is the system of the science of social engineering that has operated in tandem to make you forget the law, make you dependent upon the corporate state, and entirely take away your ability to defend yourself. So check this out.
Silent Weapons for Quiet Wars is a mysterious 44-page manual dated May 1979, which appears to be a top-secret document that outlines a covert quiet war declared in 1954 by an international elite against the general public. The document first surfaced publicly in the mid-1980s, with the most common story claiming that it was discovered by accident in July of 1986. According to this account, a Boeing aircraft employee bought an IBM copier at a government auction from McCord Air Force Base near Tacoma, Washington, and once he got home and opened it up, he found the manual inside. The document discusses society as an electrical circuit and its citizens as harvestable energy. It describes a process.
Exactly the system they've set up with the fiat currency. There is no money, there's just energy. You are the entire source of energy and credit that they have to constantly make attachments to power their lifeless corporate machine. That's why, despite the origin story of this, what's contained in it, and we'll look at it next time on the next stream, what's contained in it proves itself. It's too inhumanly smart.
By which the economy can be deliberately subjected to repeated shock through inflation, wage freezes, credit changes, and interest rate hikes, so the public stays in perpetual imbalance and recovery, too busy surviving to effectively resist the elite. The document, diversion is described as key, with sports, trivial entertainment, gambling, and alcohol being implemented to drain any energy that could fuel rebellion. Traditional family units are to be destroyed by forcing both parents to work and children into daycare from infancy. In this way, the state can become an irreplaceable authority which the people will come to depend on for their own survival. Education is to be transformed into meaningless busy work that produces obedient, technically trained, but intellectually sterile workers. Food, drugs, fluoride, sugar, pharmaceuticals, and recreational substances are to be weaponized to reduce physical and mental vitality. Ultimate surveillance of individual personal lives is to be collected, enabling preemptive neutralization of threats. Traditional religion and absolute morality are undermined so that the state is left as the ultimate authority to appeal to.
Boom. Just like I was telling you guys, if they can separate you from the creator, by the way, this is for entertainment purposes only, YouTube and Facebook. I know Rumble doesn't give a shit, but that was for entertainment purposes. I was entirely fictional and made up. And obviously, it's some conspiracy theory, some tinfoil hat wearing people tend to think is actually taking place. But with that being said, theoretically, if they can separate you from your creator, then there's no higher authority than government. And that's why in the 60s, they had that, the Star Spangled Banner, right? Playing at the end of the broadcast, the evening broadcast. And in it, subliminal messages were implanted that says, trust your government, or obey your government, trust your government God. Government is God. God is watching. God is real, and all that stuff. And that's like, it's because they need you to think government actually can make law. When in fact, and up until about 200 years ago, it was common knowledge that man cannot make law. And so therefore, when man makes any rule or regulation he tries to apply to society, it must be traceable either immediately or immediately back to law. Otherwise, it's of no force or effect. It's void, right? And even upheld in Marbury versus Madison. And guess what? The Supreme Court does not get to determine that, because the Supreme Court is a creature of the Constitution, right? And cannot determine whether or not something adheres to it or does not as the final say in that, because just as Jefferson warned, that's how you would ultimately subvert sovereignty and usurp jurisdiction. So So they think they can, but they cannot. And that's actually the opinion of Chief Justice Marshall in the Marbury versus Madison that they omit in a lot of copies and nobody really ever focuses on, is that the Supreme Court is bound to adhere to the Constitution and to the law. And anything that is opposed to the Constitution and the law is null and void, despite what the Supreme Court rules or thinks. And so that's like they said about the, what was it? About the sports and entertainment, sapping your energy. Look at this.
Last night in review, the NFL got some explaining to do. They thought they was off air last night and revealed this shit is scripted. Listen to this.
Everything.
You seen the script? You know who's going to play on? Yeah, I saw it. No? Okay. There's 15 seconds left in quarter number 3. Have you seen the script? Do you know who's going to play on? Yeah, I saw it.
Said, did you see the script? Do you know the next play at all? He said, yeah, I seen it. Then he do the evil laugh.
No. Okay.
I'll let you know later. What's funny, nigga? What's funny? We got money on this.
No, it's true though. And I've said that for a long time, even before it started coming out that it's scripted, like actually for sure, because I know there's a lot of wealthy people play sports bets. And one thing I know about wealthy people, actually know very well, because I know some wealthy people very well, they do not gamble. They do not gamble ever. They will only bet on a sure thing. And therefore, if they're placing sports bets, then they know the outcome of the game. That's just how it works. And I'm talking about not your average millionaire, couple millions of dollars right now. That's not what I'm talking. I'm talking about your billionaires, your wealthy people who play sports bets. And these guys are just the new gladiators. That's it. That's all football is. And I'm sorry, and basketball and any of it. And I'm sorry if you're a sports fan to bust your bubble, but of course it's scripted in the same way your politics are scripted, in the same way the Charlie, I'm not going to say that really because we're on YouTube and Facebook, but you know where I was going with that. In the same way that it's all scripted. The world is a stage. Everything that you see is designed for you to see it in order to influence your thoughts, beliefs, and emotions, right? And your perception of the world, of who you are, where you're at, and what the government is. Every last bit of it. So the last thing we're going to get into tonight, or today, rather, I usually stream at night, but today, is this from the Supreme Court, and I'll actually link it because it's got some cases I've verified. And this also reinforces why you have no remedy but to get them to throw it out. And if you try to fight it and you try to appeal it, once you lose, because you will lose in equity because the judge is God. In equity, of course, that's the point. And once you lose, you're going to try to appeal it. And I bet you most of you do not even know about this writ I'm going to show you. And before I show it to you, I'm going to tell you, of course, it failed, but it failed because the Supreme Court refused to look at it, not because it was inaccurate or wrong. This is why the Supreme Court refused to look at it, because the guy is 100% right. Okay. So this is a guy named John Dalen. This is right off of supremecourt.gov. By the way, this is actual case number 21-7237. You can look it up yourself and see that if you look it up in AI, you'll see that they just refused to look at it. They didn't. It's not like they denied it or anything like that. Well, they denied it looking at the case. They didn't deny it on its merits. And that tells you a lot, right? Because they know that the merits of this are exactly lawful and correct. So it's a petition for a writ of certiorari, right? Is how I believe you say that, certiorari. And if you look up what certiorari is, under Bouvier's law dictionary, right? Because that's what this definition of law dictionary adapted the constitutional laws of the United States by John Bouvier. He says, to be certified of, to be informed of. This is the name of a writ issued from a superior court directed to one of inferior jurisdiction, commanding the latter to certify and return to the former the record in that particular case. So you petition the Supreme Court for the certiorari, and he or whoever at the Supreme Court is supposed to issue the writ to the inferior court saying, all right, give me all the records of the case. We need to take a look at this because this individual is claiming that you did not follow the law, right? And you'll read exactly why this writ exists. And the fact that the Supreme Court declined to look at it is exactly my point about the Bar Association has entirely and completely hijacked our government and barred our access to law because they control the Supreme Court. They control every appellate jurisdiction. You have no remedy but to get them to throw it out before the case is disposed. So it says, by the common law, Supreme Court has, here I can probably highlight it for you guys. By the common law, the Supreme Court has power to review the proceedings of all inferior tribunals and to pass upon their jurisdiction and decisions on questions of law. But in general, the determination of such inferior courts on questions of fact are conclusive and cannot be reversed on certiorari unless some statute confers the power on such Supreme Court. It says, when any error has occurred in the proceedings of the court below, different from the course of the common law, which is absolutely what's taking place everywhere, while they'll never look at a petition like that. In any stage of the cause, whether either civil or criminal cases, the writ of certiorari is the only remedy to correct such error, unless some other statutory remedy has been given. Okay? It's your only, that's it. It's your only remedy. If you've already tried to fight inequity and lost, then you have to do this petition for a writ of certiorari to a higher court, ultimately up to the Supreme Court. And they're supposed to take and look at the case and say, hey, did this proceed according to the course of the common law? They'd never entertain that now because, again, they've barred your access to law and locked you into equity. But let's take a look at the case this guy lays out. Questions presented for review. And here I'll zoom in a little bit. Was petitioner John Dalen denied his constitutionally protected common law right to travel, where the state has converted the right to travel into a privilege? Was the petitioner John Dalen denied due process of law by the state, wherein the state ignored the common law principles of a crime, prosecuted the petitioner under statutory rules that circumvent the United States Constitution and the common law? Were petitioner's First Amendment rights violated by the state's trial and criminal conviction for not obtaining a driver's license? The South Carolina state statute requires applicants for a driver's license produce a Social Security card in order to obtain said license. Federal Social Security statutes do not require anyone to obtain a number unless that person is requesting federal benefits. Exactly. Because then you're a pauper under administration. You cannot take care of yourself. So daddy government's going to take you under administration, make you productive, and then give you a snippet of your productive value in the form of welfare benefits. John Dalen rescinded his Social Security number many years ago and no longer has a Social Security card, making it impossible for him to comply with the state statute without compromising his religious beliefs. And I assume he rightfully identifies the Social Security number as the precursor to the mark of the beast, because the digital ID and digital currency and AI governance together are the true mark of the beast. I firmly believe that, but that's just my opinion. How could I ever actually prove that other than circumstantially? But in the way that it locks you into the beast equity system and places man in the position of God, well, even worse, AI in the position of God, is why I say that. So we'll go down through the table of contents, and he's got these case citations. And these are accurate, actually, all of these. Now, I notice a lot of people post case citations, like, for instance, Murdoch v. Pennsylvania, where it says no state shall convert a liberty into a license and charge a fee therefor. That's not in Murdoch v. Pennsylvania. That's absolute bullshit. Now, you could take that case and extrapolate that that is the spirit of the case, but that exact citation, not in there at all. These citations are, I've even pulled up a few of them just to show you. It is the duty of the courts to be watchful for the constitutional rights of the citizen against any stealthy encroachments thereon. Yeah, well, the whole purpose of creating federal courts was to encroach thereon, so that's a load of garbage. But all right, so we'll go down here to the use of the highways. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and individual cannot rightfully be deprived. And we'll get into that because it's a little bit more it's a little bit more complicated with the licensing. They've really lawyered that one up, and I'm going to explain it in a moment. So here I have Hale versus Hinkle. I pulled up one of my favorite cases. This is your right to form a grand jury outside the court, which actually comes from the Magna Carta, right? So Hale versus Hinkle starts off talking about grand juries and how grand juries are able to be formed outside of the court when there's not even a case going on, just to investigate, right? Just to investigate somebody. So it says, under the practice in this country, the examination of witnesses by a federal grand jury need not be preceded by a presentment or formal indictment, but the grand jury may proceed either upon their own knowledge, upon examination of witnesses, to inquire whether a crime is cognizable by the court has been committed. And if so, they may indict upon such evidence. So nowhere is the state needed for that until after they've discerned that there is a crime committed, and then you go through the court, right? But the grand jury has often been called the fourth branch of government, even though it's not government, it's the people. And that is our check and balance against the court. It's supposed to be anyways. So in this particular case, what happened is they were investigating this corporate corruption, and they get one of the chief officers of the corporation. They form a grand jury on their own, and the court did not have to do it for them. They form a grand jury. I'll show you where we get that right. Okay. They formed a grand jury, and they basically subpoenaed this corporate officer for questioning. And the corporate officer refused to answer any of the questions of the grand jury because he's like, there's no charges. I have the Fifth Amendment to, not incriminate myself, and et cetera, et cetera. There's like, well, there's no crime. There's no threat of incrimination. And not only that, you have to answer a question. So they ordered the justice of the peace to go ahead and lock him up for contempt. And they did. And then so he does a writ of habeas corpus and goes, hey, why am I sitting in here? There's no charges. There's no nothing to produce the body of the crime. Habeas corpus, right? Why am I here? And the court had to deny it. They said, listen, the court doesn't have you sitting in there for contempt. The grand jury does. And they're above me, and there's nothing I can do about it. So if you guys want me to link this citation, this case, you guys got to read this. And I'm not done going through it, but that's mainly the power of this case, essentially, is in the power of the grand jury. Where we get the power of the grand jury is right here in the Magna Carta from 1215. This is Article 61. Now you go, oh, there's no way. How does that apply to the United States? Well, I'll show you. This is the Michigan compiled laws of 1929. And in the jurisdictional documents right here that they always list first to show their authority, it goes Magna Carta, then Declaration of Independence, then the Constitution. Look at that. Magna Carta, Declaration of Independence, Constitution. So you wonder if, and they had to do that because the prescription for administration and taking fees and taking control of people's estates is also in here. Those are also in here. And that's why I call the Magna Carta a double-edged sword. But if you know the law and you know what you're doing, it is a great charter of liberty. And this is one of the reasons why. So since we have granted all these things for God, for the better ordering of our kingdom, and to allay the discord that has arisen between us and our barons, and since we desire that they shall be enjoyed in their entirety with lasting strength forever, we give and grant to the barons the following security, which translated in our country, our republic, as a grand jury. And it's the security against the abuses of government. It says the barons shall elect 25 of their number to keep and cause to be observed with all their might the peace and the liberties granted, confirmed to them by this charter. Says if we, our chief justice, our officials, or any of our servants offend in any respect against any man or transgress any of the articles of the peace or of this security, and the offense is made known to the 4 of the said 25 barons, which goes back to the investigative committee of the grand jury, right, consisting of 4 members, they shall come to us, or in our absence from the kingdom, to the chief justice to declare it and claim immediate redress. If we, or in our absence abroad, the chief justice, make no redress within 40 days, reckoning from the day on which the offense was declared to us or him, the 4 barons shall refer the matter to the rest of the 25 barons, who may distrain upon and assail us in every way possible with the support of the whole community of the land by seizing our castles, lands, possessions, or anything else saving only our own person and those of the queen and our children, until they have secured such redress as they have determined upon. Having secured the redress, they may then resume their normal obedience to us. And not only that, but you're allowed to swear an oath to this 25 barons and now to the grand jury, right? And so that's how they were able to. So they gave the barons the ability to form a grand jury. It wasn't called that then, and then basically fix things by whatever means possible. Does not matter. You can take our castles, you can take our property, you can take all our stuff, and you're justified in doing it. Now, guess what? in the later editions of the Magna Carta, say 1295, that's not in there anymore. They took it out. But we still have it because we recognize in this document here, the Magna Carta that's in here is the original 1215 Magna Carta. And that's the one we recognize here in the Republic as the fountain authority of the common law. Not the fountain authority, because that's God, but as the securing charter of the common law in Western Anglo, society. So anyway, yeah, thought that was interesting. Let's hop back over here. Right here. All right. So, we were at Hale v. Hinkle, weren't we? My bad. Here. Okay. So, we're going to do Control F, and yeah, no duty, right? So read this. So the individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom beyond the protection of his life and property, or rather the vehicle through which he may do that would be a more accurate way to say that, because the state doesn't directly protect your life or your property. It's up to you to do that, and then you're justified and vindicated by the courts. So his rights are such as existed by the law of the land long antecedent to the organization of the state. So his rights are such as existed by the law of the land, long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution, which means by an actual victim for an actual crime, right, with actual due process and a jury. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Now it gets even better. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law. It can make no contract not authorized by its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. See? So the corporation is a creature of the state. It is an enfranchisement. Well, guess what the 14th Amendment is? It's not specifically a corporation. It's a decedent estate under administration, but it is also an enfranchisement of a corporation. It's an enfranchisement of the debtor corporation known as the United States. And as we have seen earlier, right, that I pulled up right here, the United States citizen has no access to the common law guarantees of the Bill of Rights, has no access to it. It says the first 8 amendments, the privileges and immunities of the citizens of the United States do not necessarily include all the rights protected by the first 8 amendments of the federal Constitution against the powers of the federal government. What? Why is that? Well, it's because you're not one of we the people. You are a trustee, an agent of a debtor principal who has been mortgaged. This is Maxwell v. Dow again, in case people did not know which case that was. Maxwell v. Dow from 1900. So anyway, that was Hale v. Hinkle. Hurtado v. California. State cannot diminish the rights of the people. Due process of law. Due process of law is process of law according to the law of the land, which is common law, i.e. the Constitution is exercised within the limits prescribed and interpreted according to the principles of common law. Boom. There's a more accurate way to say it, but yeah, exactly. Constitution is supreme law of the land. Any law in conflict is null and void, even if the Supreme Court, and Chief Justice Marshall says this in his opinion, even if the Supreme Court says it is not in conflict with the Constitution, right? If it very blatantly is okay, so take, for instance, the merger of law and equity in 1938, right? Well, now you've just abridged the 6th and 7th Amendments. You've abridged the right of the accused to know the nature and cause of the charges against him, because the judge does not have to honor that in equity, though they don't want to, they don't want to expose that. So that's why they just dismiss it, like we've seen with the Ryan Michael Thor case. But so the 6th Amendment to know the nature and cause of the charges against you, to face your accuser which is the Sixth Amendment. Well, in equity, who's the accuser? There's no victim. And the witness is against him. There's no witnesses. There's no victim. The cop tries to be a witness, but under the Magna Carta and under just the general common law, you cannot do that. It's a conflict of interest. Ask the cop next time you're in court with the traffic ticket, hey, are you being paid to be here today? See what he says, right? Probably he's because he's dumb. He's going to be, oh, yeah, of course I am. Right. Okay. Well, it's conflict of interest. I move to dismiss. So, but you don't want to get to that point. You want to challenge at arraignment. You'll never win in equity. Anyways, Chief Justice Marshall said, yeah, it doesn't matter. If it's in conflict with the common law or with the Constitution, it's null and void. So we're going to go down here to see now this is not in there. So we'll actually look up Murdoch v. Pennsylvania. We'll see, because I did not, but everything else he put in here was actually in there. So maybe I missed it. V. Pennsylvania. So let's see here. Just check. Whatever. Spelt it wrong, but Justia. And then, so how is it exactly written? Here we go. Okay, we will do a copy. This is the best way to see if a citation is authentic. Control find. And then Control F, on a computer. Paste. It is not in there. It's not in here at all. So you could infer from, because I read the case, it was about trying to get Jehovah's Witnesses to acquire a license to exercise their First Amendment. And that's ultimately what the court held, right? And so you could extrapolate that was in there, but that exact citation is not in there. So beware. Beware when you're citing something, you want to go look it up every single time. All right. That's what I do. So we're going to go down here to this one. This is the other case brought up, Thompson v. Smith. Now, this is what's interesting, what I said I was going to get to later about the licensing. The right of the citizen to travel is not a mere privilege, but a common right, which he has under his right to life, liberty, and the pursuit of happiness. However, if you read that case, which of course you know I did. Here's where it says that, right? So the right of a citizen, here, let's get rid of that. The right of a citizen to travel upon the public highways and to transport his property thereon in the ordinary course of life and business is a common law right, which he has under his right to enjoy life and liberty, to acquire and possess property and to pursue happiness and safety. It includes the right in so doing to use the ordinary and usual conveyances of the day. And under the existing modes of travel includes the right to drive a horse-drawn carriage or wagon thereon, or to operate an automobile thereon, for the usual and ordinary purposes of life and business. It is not a mere privilege, like the privilege of moving a house in the street or operating a business stand in the street or transferring persons or property for hire along the street, which a city may permit or prohibit at will. The exercise of such a common right, the city may, under its police power, regulate in the interest of public safety and welfare, but it may not arbitrarily or unreasonably prohibit or restrict it, nor may it permit one to exercise it and refuse to permit another of like qualifications under the same conditions and circumstances exercises. So what does that mean? This case actually found that it was lawful for the state to require, and I disagree, and obviously you should too, because the very word license means permission to do something unlawful that would otherwise be unlawful. But it falls under the purview of the police power of the state, this guy said, to require a license. However, you cannot revoke it. Okay, you can require the license for basically maintaining public safety and administering, the use of it, basically, like the speed limits and all that, which I entirely disagree. And they couldn't even start doing this till they took you under administration. But anyways, but what he's saying, and what this is a good case to cite for, is when your license has been suspended or your registration has been suspended or any of that type of stuff, if you want to use one and actually give your property to the state, right? This is the only thing this would be good for, in my opinion, because it's still in it. It starts off with, it's perfectly acceptable for them to require a license to use an automobile on the public roadways. However, you cannot give the sheriff the power to revoke, right? So right here, it says the provision authorizing the chief of police to revoke the permit of any driver who, in his opinion, becomes unfit to drive an automobile on the streets of the city is void because it is a delegation of legislative power to an administrative officer, which is what they've done with delegating this to the DMV in the first place. Right? So by the creation of the DMV, which I think this case precedes the creation of the DMV, but anyways, with the creation of the DMV, they did the very thing that this case admonishes. It says, in that it authorizes the chief of police to revoke a permit whenever, in his opinion, the holder thereof has done or committed to, or omitted to do something, the doing or omission of which the chief of police thinks renders the holder unfit to drive an automobile on the streets of the city without prescribing any uniform rule applicable to all persons alike. Right? So basically, this case is just about the chief of police being able to arbitrarily revoke and grant licenses based on his opinion without any legislative body. This case is not what you think it is, because the bar pirates that control the court system still want you to be licensed, tagged, tracked, and all that stuff. And I guess this judge thought he was being fair in ruling that, well, it's a right, but we still can license it. What? What the hell are you talking about? It's a fundamental common law right, but we can still license it. And that's why people who cite this case in any of the cases you really cite, except for the really old ones that I show you, are pretty much useless. And if you stay in equity, it's all pretty much useless, because the bar pirate is the god of that courtroom, and that's how it works, right? So anyway, that's that. I'll link this. One thing we can do real quick is look at the disposition of this, because I already looked it up earlier and seen what it said. And so this is number 21-7237. So Supreme Court case. I say, what happened in Supreme Court case 72 or 21-7237. 21-7237. 21-7237. Okay, watch. Oh, now it's not going to give me the AI disposition of it, or is it? Copilot. Let's see what it says. Sure. No, I'm not. I'm a man. No, I'm just kidding. Well, no, I am. Human is an animal. It's a beast, but yep, it says it says denied petitioner's motion to proceed in forma pauperis, which that might be one of the big reasons why they were so easily able to refuse to look at it. Because if you're going to claim sovereignty and common law right, but you need to proceed as a pauper, well, that's a problem, right? But anyways, they refused to look at it, is the point. So they didn't deny it on its merits, because actually he lays out the exact right case, minus that one citation that was not in Murdoch v. Pennsylvania, but he lays out the exact right case. So this is how the bar pirates deal with something like this, where it's like, okay, it's the writ of man, remembering how to pronounce this word is difficult. What is it? Certiorari. Yeah, the writ of certiorari is powerful writ, right? Petitioning for it. And so if they do it and they look at it after reviewing all of these cases and all of the evidence in the case that he made against the state, they would be forced to question the validity of licensing in the first place. And so they're like, it's easier just not to look at it. And because they now make, guidelines in equity, I'll show you. This is Federal Rules of Civil Procedure, Rule 2. This is the product of that unification of law and equity and civil and admiralty. It's all just been unified into one hodgepodge called UCC, right, under the Commercial Equity Administrative System, or the Administrative System of Commercial Equity, rather. It says right here, suits in equity when not sustainable, blah, 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 conferring power on the Supreme Court to make rules of practice in equity. When what did Bouvier or Blackstone say about equity? It said that there can be no established rules or principles in equity because it's case by case, right? Which I'm now off of. It was like 62, I think. Yeah, it was 62. No, man. Wow, that went fast. 62. At least I thought it was. Is it 62? Yeah, right here. Equity thus depending essentially upon particular circumstances of each individual's case. There can be no established rules and fixed precepts of equity laid down without destroying its very essence and reducing it to a positive law, which all a positive law is basically a statutory enactment that's going to be given the force of law if you're in a position to have it applied to you, which all 14th Amendment citizens are, right? Because your access to law is barred and you're trapped in equity. So they're making rules of practice in equity, right? Scumbags. One form of action, the civil action, which is a foreign law, the very same law referenced in the Declaration of Independence, right? Whoops, not Declaration of Independence. Look at that, National Archives. And if you do a Control F and type in jurisdiction, whoops, yeah, jurisdictions right there, has combined with others to subject us to jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, right? And where is it? Somewhere else down here, it says for prosecuting us, yeah, right here, for transporting us beyond seas to be tried for pretended offenses. That's what's going on today. That's what civil action is. That's what it's become. And that's what it's always been, a foreign form of law. It's Roman civil law, which whether they just call it civil law or they call it Roman civil law, it's still foreign. And it's foreign to the common law nations. That's it, period, point blank period. So, and then just like we've seen in the Articles of Association, right, which were, pull those up at Articles of Association, right here, where they're talking about, it says that they implemented a ruinous system of colony administration, which is what we're under, because that's trusts are administered, right? We've now become a national trust adopted by the British ministry, evidently calculated for enslaving these colonies, and with them, the British Empire, in prosecution of which system various acts of parliaments have been passed for raising revenue in America and depriving the American subjects in many instances of the constitutional trial by jury. Right. And then it also says that it takes them beyond the seas as well, somewhere else down in here. So that's the Articles of Association, 1774. So we're at that point. And until we get a critical mass of awakening to where we can get enough people to force the government to either do what we want or we abolish it, and return to our common law roots and our the original Articles of Confederation, rather, the original Confederacy. Right, the principles of this, because all states are Confederate, including Michigan, right? And I've proven that many times before. I'm not going to hunt down the document right at the moment, but I do have it archived. And that's because our union is Confederate. And when a union is Confederate, not corporate, the sovereignty resides within the states. That's Penn Hollow versus Stone's Administrators. Last thing I'll show you. Oops. It's right here, and you do this. Control find, type in Confederate, right? So let's see, where is it at? Boom, boom. Stupid thing. It's going to be difficult. It says not corporate, right? Not corporate, or is it our Confederate, not corporate? There we go. Okay. It's right there. It says, but wherever an alliance is not corporate but Confederate, the sovereignty resides in each state. Now, this is 1795, after the Constitution. Our style of union is a confederacy. And that's really what the Civil War was all about, was destroying state sovereignty. And obviously the Reconstruction Amendments they used to enslave everybody. It gave rise to the modern prison system and created a national trust indenture. And it says the sovereignty resides in each state. And it says, now, the state retained all powers which she did not expressly surrender to the Union. A state cannot cease to be sovereign without its own act, nor can sovereignty be asserted but upon a clear title. And with that, ladies and gentlemen, I will leave you for today. We will pick up probably on the Silent Weapons for Quiet Wars. Go check out Matt Schneider's Facebook page or his X page and check out that video. And he's got some other good videos on there. He's all for freedom on X. And then we'll get back. We'll come back and we're going to actually talk about the modern implications of the intelligence or applications rather of the intelligence community, the social engineering that's taking place with the artificial intelligence governed for you pages, right? That specifically select content to manipulate your emotions and engineer your behavior and all that good stuff. And most of all, they want to keep you dumb, distracted, and ignorant of the law and how to break free from this. Remember, the 14th Amendment is the Jenga piece that destroys everything. So I speak at length about it. And really, if we just stand up and demand a review of the amendment process or the ratification process of the amendment, it's gone and the whole thing collapses. So with that, you guys have an excellent day, and I will see you next time.